is strengthened by your response to jury duty this morning. Now, I recognize that each of you are making a sacrifice by being present here today, and I know it represents some inconvenience to each of you, but I also believe that you will recognize that jury service is necessary. The jury system that we use here is a system that lets everyday people decide issues that affect other everyday people. So the sacrifice being made is a sacrifice necessary to ensure that we continue with this justice system. Now, some of you may be feeling a bit nervous or stressed at the thought of having to serve as a juror. Those are common expressions, often stated by prospective jurors who have never served before. Many people think they don't know what jury duty entails or that they're capable of performing the duties of a juror, but I want to assure each of you that you are all more than capable of serving and performing the duties of a juror. Now, it's my hope that you will find your juror service to be valuable and interesting, and I can tell you that after each trial is done, I speak with the jury privately, and almost all of them express the gratitude that they were here, that they got called, and often express that they want to come back and serve again. Now, you've been summoned as a prospective juror in a criminal case entitled State of Ohio versus Mark Jackson, Jr. Mr. Jackson is the defendant in this case, meaning that he is charged with committing a criminal offense. Specifically, the indictment alleges that in count 1, on or about the first day of January 2025 in the city of Painesville, Lake County, Ohio, Mark Jackson Jr. did knowingly cause or create a substantial risk of physical harm to an adult female, a family or household member, and or a person with whom Mark Jackson Jr. is or was in a dating relationship by means of strangulation or suffocation. The said Mark Jackson Jr., having been previously convicted of or pleaded guilty to a felony offense of violence in the Cuyahoga County Court of Common Pleas, case number CR 21-659-273, dated July 20 of 2021. In count 2, it's alleged that on or about the first day of January 2025 in the city of Painesville, Lake County, Ohio, Mark Jackson Jr. did knowingly cause or attempt to cause physical harm to an adult female victim, a family or household member. The said Mark Jackson, having been previously convicted of or pleaded guilty to domestic violence in the Cuyahoga County Court of Common Pleas, case number CR 21-659-273, dated July 20 of 2021. The indictment filed in this case, which sets forth the charges that I read to you, are not evidence. It is used to inform Mr. Jackson that he has been charged with these offenses. The fact that it was filed may not be considered for any other purpose. Mr. Jackson has pled not guilty to the charges. The plea of not guilty is a denial of the charges in the indictment and puts in issue all the essential elements of each offense. The state of Ohio and Mr. Jackson are entitled to jurors who approach this case with open minds until such time as a verdict is reached. It would be unfair and improper for you to decide this case based only on part of the evidence or without hearing the court's instructions or the arguments of counsel. Do not jump to conclusions on the basis of the first or the last argument or the first or the last evidence that is presented to you. In addition, jurors must be free as humanly possible from bias, prejudice, or sympathy and not influenced by any preconceived ideas either as to the facts or to the law. You will receive the facts from the witness stand. Instructions as to the law will be given to you by the court, and it is your sworn duty to accept and apply these instructions that I give to you. Now, I want to begin by explaining the process by which some of you will be chosen to serve as jurors in this case. As I said, each of you are undoubtedly qualified to serve as a juror. However, there could be something that could disqualify you in this particular case or the specific facts or issues presented in this case. Therefore, we're going to go through a process whereby I ask you questions, counsel for the state will ask you questions, and counsel for the defense will ask you questions. This part of the trial is called voir dire. It's an opportunity for the court and the attorneys to learn a little bit more about you to make sure that we have a fair and impartial jury in this case. These questions are not designed to pry into your personal affairs. but to discover if you have any preconceived notion or anything in your past or a family member's past or you've got an opinion that you cannot set aside. These questions are necessary to make sure that each party has a fair jury in this case. I'll ask you questions first as a group. If you have a response to the question, please raise your hand and you'll be called upon. Every time a juror speaks, that juror number must be noted either by the person asking the question or by the jury answering the question. This is done so that we have a clear record of who is responding to the questions. Now, as I said, these questions are not intended to be offensive in any way, but to discover if you have something in the past that would prevent you from being a fair and impartial juror. And if that is the case, then that person would be excused for what is called good cause. After we're done, after you're done being questioned, I'll meet with counsel out of your presence, at which time 13 individuals will be chosen to serve as jurors in this case. One of the 13 will be an alternate, and that person will not be identified until the close of the jury instructions. And I must stress to you the importance of answering all questions honestly. We need you to be open and honest. If there's something that you don't want to talk about in front of the whole panel, let me know that and we can talk individually. Now, seated directly in front of me, representing the state of Ohio, are Assistant Lake County Prosecuting Attorneys Taylor Linden and Joshua Knopf. Would you introduce yourselves, please?
I'm Taylor Linden, Assistant Prosecuting Attorney from the Office of Mr. Charles Colson. With me is my co-counsel, Joshua Knopf, and seated to his right then is Officer Chad Woloski from the Kingsville Police Department.
Thank you. And seated at the other table are attorneys Rachel Smith and Thaddeus Quicklinski. Would you introduce yourselves, please?
Good morning. I'm Rachel Smith, Defense Counsel on behalf of Mr. Jackson, who's seated against the wall here.
And I'm Thaddeus Quicklinski for Mr. Jackson.
All right, thank you. Bob Gonzalez is our bailiff. You've already met him. It's his responsibility to keep you together and to not permit any person to speak with you during the course of the trial. He will direct you where to go throughout the trial. Kathy Miller is our court reporter. She's responsible for recording and taking down everything that is being said in court. It's important for the witnesses, the jurors, the lawyers to speak loudly and clearly enough for the court reporter to hear them. And because people have a tendency to nod or shake their head in response to a question, you will hear me probably quite often ask you to verbalize your answers. It's her job to take a clear record of what goes on in this case. Now, those who participate in a trial must do so in accordance with established rules. This applies to witnesses, the lawyers, the judge, and the jurors. The lawyers present the evidence through the questioning of witnesses, which must be done according to the rules. The judge enforces the rules and determines what evidence may be admitted. At times during the trial, a lawyer may make an objection to a question asked by another lawyer or to an answer by a witness. This simply means the lawyer is requesting that I make a decision on a particular rule of law. Do not draw any conclusion from the objections or from my ruling on the objections. These only relate to legal questions that I must determine and should not influence your thinking. As jurors, you will be the sole judges of the facts, the credibility or believability of the witnesses, and the weight to be given to the evidence. Later, the court will furnish the law, which you will apply to the facts. It is your sworn duty to accept the law as it is given to you by the court. Once the jury is selected, the procedure for the trial is as follows. First, the state will outline in an opening statement what they expect the evidence will show. The defense may then, but need not, make an opening statement. These opening statements are not evidence. They are a preview of the claims of each party designed to help you follow the evidence as it is presented to you. Then the state offers evidence in support of its claim. The defendant may then present evidence but is not required to do so. If the defense does offer evidence, then the state may offer rebuttal evidence. The trial concludes with the instructions of law and the arguments of counsel. You would then deliberate on your verdict. A criminal case begins with the filing of an indictment. The indictment informs the defendant that he has been charged with an offense. The fact that it was filed may not be considered for any other purpose. The plea of not guilty is a denial of the charge and puts in issue all the essential elements of each offense. The defendant is presumed innocent until his guilt is established beyond a reasonable doubt. The burden of proof is on the state of Ohio to prove the facts necessary to prove its case beyond a reasonable doubt. The defendant must be acquitted unless the state produces evidence which convinces you of his guilt beyond a reasonable doubt of every essential element of the offenses charged in the indictment. Reasonable doubt is present when, after you have carefully considered and compared all the evidence, you cannot say you are firmly convinced of the truth of the charge. Reasonable doubt is a doubt based on reason and common sense. Reasonable doubt is not mere possible doubt because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of his or her own affairs. Evidence is all the testimony received from the witnesses, the exhibits admitted during the trial, and facts agreed to by counsel, and any facts the court requires you to accept as true. Evidence may be direct or circumstantial or both. Direct evidence is the testimony given by a witness who has seen or heard the facts to which he or she testifies. It includes exhibits admitted into evidence during the trial. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may reasonably infer other related or connected facts which naturally and logically follow according to the common experience of mankind. Direct evidence and circumstantial evidence are of equal weight. The evidence does not include the indictment or the opening statements or closing arguments of counsel. The opening statements and closing arguments of counsel are designed to assist you. They are not evidence. You are the sole judges of the facts, the credibility of the witnesses, and the weight of the evidence. To weigh the evidence, you must consider the credibility of the witnesses. You may apply the tests of truthfulness which you apply in your daily lives. These tests may include, but are not limited to, the appearance of each witness upon the stand, the reasonableness of the testimony, the opportunity to see, hear, and know the things concerning which they testified, the accuracy of memory, frankness or lack of it, interest and bias, if any, together with all the facts and circumstances surrounding the testimony. Applying these tests, you may assign to the testimony of each witness such weight as you deem proper. You are not required to believe the testimony of any witness simply because they were under oath. You may believe or disbelieve all or any part of the testimony of any witness. It is your province to determine what testimony is worthy of belief and what testimony is not worthy of belief. The testimony of a defendant is to be weighed by the same rules that apply to other witnesses if the defendant takes the stand and testifies. The defendant has the constitutional right to not testify in this trial. If the defendant chooses not to testify, you shall not consider that decision for any purpose. You should not decide any issue of fact merely on the basis of the number of witnesses who testify on each side of an issue. Rather, the final test in judging the evidence would be the force and weight of the evidence, regardless of the number of witnesses on each side of an issue. The testimony of one witness believed by you is sufficient to prove any fact. The court instructs you not to converse with the attorneys, parties, or witnesses during the trial. Likewise, the participants in the trial must not converse with you, and in fact, they are ordered not to talk to you until after the case is concluded. If anyone should attempt to discuss the case with you, report that incident to me or to the bailiff immediately. Do not investigate or attempt to obtain any additional information about this case outside the courtroom. It is improper for any of you to attempt to do so. You are instructed not to read, view, or listen to any report in any media on the subject of this trial. Do not permit anyone to read or comment upon them to you or in your presence. Such reports may be incomplete and inaccurate. You may only consider and decide this case upon the evidence received at the trial. If you acquire any information from an outside source, you must report it. If you realize during the course of the trial you have personal knowledge of any facts in this case, inform the bailiff as soon as possible. All right, now as I said, I'm going to ask you questions first as a witness. If you have a response, raise your hand. I'll call on you, and then remember, you got to speak loudly and clearly so that Ms. Miller can take down everything that is being said. The first question that I have this morning is, Was anybody at the, before they came here this morning, at the McDonald's on Richmond Street? Did anybody stop there this morning? Okay. All right. There's a, it's a goofy question, but there's a reason I asked it. All right. First of all, does anybody know any of the four attorneys in this case? Juror number 21, who do you know?
Taylor. I don't really know Taylor, but I worked with her mom several years ago and purchased a car from her dad.
Did you get a good deal on that car?
Yes.
All right. The fact that you know of Taylor and you had some dealings with her parents, would that, if you are seated as a juror in this case, would that influence you one way or another?
I don't think so.
All right. Will you commit to me that you'll listen to the evidence and decide this case based only on the evidence you hear and the instructions I give you?
Yes.
Okay. Anybody else? All right. Does anybody know the officer seated at the table? All right. When, instead of verbally answering, because there's no way she could figure out who that is, just raise your hand if you have a response to a question, okay? All right. Does anybody know me? Juror number 1, how do you know me?
I think we went to high school together. You were the football quarterback and point guard for Lake Ave.
Does your son know my son also?
Yes.
Okay. All right. If you're called to serve as a juror in this case, would the fact that you know me and your son knows my son, would that have any influence on you whatsoever?
No, will not.
All right. Will you commit to me that you'll decide this case based only on the evidence that is produced at the trial and the instructions that I give you?
Yes.
Okay. Anybody else? Number 16, how do you know me?
I grew up with you in Wick.
All right. Is that good or bad?
You tell me.
And occasionally we bump into each other here and there, right?
Right.
All right. If you're selected to serve as a juror in this case, would that have any influence over your decision at all?
No.
Would you listen to the evidence and decide this case based only on the evidence and the instructions that I give you?
Yeah.
Okay. Anybody else? All right. Do any, and remember, if this applies to you, when I ask you this question, I want you to use only juror numbers and not names, okay? Do any of the potential jurors know each other? Okay, let's start with juror number 5. Which juror number do you know?
Which would you know? 25.
Okay. Told you not to use names, didn't I?
I'm sorry.
That's all right. How do you know juror number 25?
Kind of close together.
When's the last time you saw 25?
Well, out on the bench.
Besides today?
Before that, probably about a month ago.
Okay. What were the circumstances of that?
Honestly, I don't remember where we were. I saw him, but it was actually the village where we live in Perry.
Okay. And how often would you say on the average that you guys run into each other?
Once or twice a year.
All right. Now, if you're seated as a juror in this case, and 25 is seated as a juror, and you go back there and you start to deliberate, and you guys start talking about the case, and you decide it should come out one way, and he decides it should be another way, okay? Would you be able to listen to his argument?
Yes.
Would you be able to, if you thought his argument was a bad argument, would you be able to maintain your own position?
Yes.
Okay. And let's say you still can't, the two of you still disagree. If you ran into him in another month out on the street somewhere, would that cause a problem in your relationship?
No.
Okay. 25, same questions to you, would you listen to number 5's arguments in the deliberations?
Yes.
All right. If you thought he was wrong, would you maintain your own position?
Yes.
And do you think that will cause you, if you still were on opposite ends, that will cause you a problem in your relationship such as it is?
No.
Okay. All right, I think we had number 13. Did you have your hand up? Which juror number do you know?
Know his number, but Cliff Brewster.
Ah. All right, what number are you? 27, okay. All right. How do you know 27?
We went to high school together, we wrestled.
And roughly, ballpark, how long ago was that?
I graduated in '75. I think he graduated 3 or 4 years after me.
Okay. When's the last time you saw juror number 27?
I saw him maybe 5, 6 years ago at his place of business.
All right. Okay, if you're, you heard the questions I asked of 5 and 25. If you guys are seated together and come up with some disagreement and can't resolve that, would that affect your relationship with him?
No.
Would you feel pressure to come over to his side if it felt differently?
No.
And 27, same questions for you. If you guys were at odds, would that cause a problem next time you saw number 13? And will you be able to maintain your own position if you think you're right and he's wrong?
Yes.
Okay. All right, anybody else over here that had their hand up? Okay, in the back, who had their, all right, juror number 17, which number do you know?
28,
Okay, how do you know 28?
prior neighbors,
How long ago?
they moved out 8 years ago. Always see, social media, really think we don't run into each other too much.
Okay.
Just see on social media what's going on in life.
Do you guys communicate directly over that social media? Or do you just see posts that,
Just post, comment, likes or something like that.
okay. All right. You've heard the questions now twice before, but in the event that you two are seated as jurors and you disagree as to the outcome, would that affect the nature of your relationship?
No.
All right. If you felt that you were correct, would you listen to 28's arguments and consider those arguments?
Yes.
All right, 28, same questions for you. Any problem if you guys look at the facts, sit there, listen to the facts, and decide differently? Gotta speak up.
No problem.
Okay. Would that affect any relationship at all that you have over the social media? Okay. All right, who else had their hand up? And that's with regard to number 13 or somebody else?
25.
All right, 27 and 25. 25 knows everybody. How do you know 25?
We used to be in the same business. I have my son, he has a business together.
Okay, how long ago did you last see each other? A year?
Feeling if I went to the,
All right, do me a favor, because since you're in the back, keep your voice up, okay?
okay,
You said you don't live far from each other?
probably 2 miles. But
All right, are you still in that business?
not retired.
If you guys are seated together, would that affect your relationship that you have with him at all? All right, would you be able to decide this case based only on the facts that you find and the instructions I give you?
Yeah.
25, any problem if you serve with 27, you guys disagreed?
No.
All right, would you maintain your own position if you thought you were correct?
Yes.
All right, anybody else? And 28 and 17, right? No, who else?
Next to him.
26? Between 25 and 27?
Where's Green?
All right. All right, 28, how do you know 16?
He is my brother-in-law's dear friend.
How often, when's the last time you saw 16?
It's been a couple years.
Okay. I've already asked you these questions, but if you guys are seated together, would it tick off your brother-in-law if you had the opposite of 16?
No problem.
Okay. Any issue with you, number 16? No? Okay. All right, anybody else before we leave this? All right. I read you the indictment that was filed in this case. Does that ring a bell to anybody? Anybody have any knowledge of this case? Now, who here has served?
Your Honor.
Yep, yes,
I think I read something in the news about it, but I'm not sure.
okay. Do you know when that would have been?
About a week ago or something like that.
Okay. All right,
You guys don't remember, by the way.
so does everybody else. But I can assure you, what newspaper do you think you read it in?
I read it like an iPad, you know, like local news and stuff like that.
Okay. Was it like the News Herald or something like that, or?
No, it's something like an iPad, I got the news app. and
Okay.
It covers local and
Okay,
nationwide.
okay. My guess is that it didn't show up in any news feed, but in the event that.
It was something like that, but like I said,
All
I'm
right.
not sure, 100%.
Okay, so if you're seated as a juror in this case, would you discount anything that you read, that you remember that you read about this situation, and decide this case only on the witnesses you hear and the evidence that you see?
I would only go by witnesses. but-
Right. Okay, so you would completely discount what you think you may have heard?
Right.
Okay. All right. Okay, I'm looking for people who served on jurors before, and by that I mean people that were called in this situation, but then actually got picked to serve as a juror. Anybody, that apply to anybody. Juror number 6, when did you serve?
Served on the grand jury in 2012. Sometime.
Okay. And in your service as a grand juror, if you remember, 13 years ago is that you heard several cases a day, correct?
Yes, sir.
And you only heard the side of the state of Ohio, the prosecutors, right?
I believe so.
Okay. And your job as a grand juror was to decide whether there was probable cause to believe that that specific person committed a specific crime. Is that your recollection?
That's my recollection.
Okay. And in this situation, if you're selected as a juror, your job is to listen to and evaluate the evidence, listen to the instructions, and then decide whether Mr. Jackson committed one or both of these offenses with the standard of proof being beyond a reasonable doubt. Do you understand that?
Yes.
Completely different from the probable cause standard. Do you understand that?
Yes.
All right. Would you have any issue doing that?
I don't believe I would.
Okay. All right, anybody else? Let's go number 12, go ahead. When did you serve? Approximately.
Probably like 30 years ago, Jug County. I was chosen as a juror, but we never actually went to trial.
Okay. Anything about that service that would prevent you think, from being a fair juror in this case?
No, not at all.
Okay, anybody else up here? All right, let's go in the back. 60, 70, number 19, when did you serve?
34 years ago, in Lake County Courts.
Do you remember what kind of case it was?
I would imagine it was criminal.
You don't specifically remember, though?
I can tell you the name of the case, I don't know if that would.
You can tell me the name of the case from 34 years ago? She's got a good memory, you know what I'm talking about. What was the name of the case?
It was the BDD Bandit case.
Okay. All right, did you deliberate in that case?
Yes, I did.
And did that jury come to a conclusion?
Yes, we did.
All right. Now, please tell me you don't remember the jury instructions from that case, right?
No.
Okay. If you're seated as a juror in this case, would you be able to decide this case separately from the one you previously served on?
Yes, sir.
And will you be able to decide this case based only on the evidence that you hear and the instructions I give you?
Yes.
Is there any reason you think you could not be fair and impartial to both sides in this case?
No, Your Honor.
Okay. All right. Who else back here? I saw another hand. Number 25, go ahead. Tell me when.
30 years ago in Lake County.
Do you remember if it was criminal or civil case?
I would believe that's a civil, DUI related.
Okay. All right. Anything about that case that do you think would prevent you from being fair to both sides in this case? Would you discount everything about that case if you're seated here and decide this case based only on the evidence and the instructions? Okay. Who else? Anybody else? Number 21, go ahead, tell me about it.
It was probably 25 to 30 years ago, and it was Painesville Municipal Court,
Okay.
and I believe it was a DUI case.
All right. Anything, did you deliberate in that case?
Yes,
And did the jury come to a conclusion?
yes.
All right. Anything about that case that would cause you not to be fair to both sides in this case?
No.
Okay. Anybody else? All right. Has anybody on the panel had any type of legal training of any sort? That could be anything from, police officer training to paralegal training, anything like that. All right, let's go with number 3 first. Go ahead.
I'm not sure if it's the same, but I've had Title IX training through higher ed.
Is that the sports stuff?
It's sports, but it's also cases of equity, intimate partner violence, bystander intervention.
Okay. When did you have that training?
2018 and 2022.
Okay. Anything about that training that you had and that experience that would cause you to favor one side or the other in this case?
I don't think so.
Okay. If you're seated and you listen to the evidence and you decide, well, that doesn't make sense, or that's not correct because my training says this, that, or the other thing, would you discount that and decide this case based only on the evidence and the instructions I give you?
Yes.
Okay. All right, and I saw another hand go up somewhere. Number 24.
I was a part-time police officer for 14 years,
How long ago was that?
86 through 99.
And what departments did you work at?
Sugar and Falls Police and Lake Country Park Rangers.
All right, anything about your service as a police officer that would prevent you from being fair to each side here?
No.
Now, there's going to be some police officers that testify in this case. Would you give them any greater weight simply because they're police officers?
Absolutely not.
Would you give them any lesser weight simply because they're police officers?
No.
You would be able to to give a fair shot to both sides here?
Absolutely.
Okay. All right, anybody else? Number 22, go ahead.
I'm not sure if this applies, but in core business law, I was the manager of the contracts and purchasing department at the Federal Reserve Bank of Cleveland and negotiated with our legal team contracts. So, not
Okay.
sure if this applies or not.
So, with the Federal Reserve Bank? All right. Do you think they're going to lower interest rates here?
cultural too.
Anything about your training and experience that would cause you to favor one side or the other here?
You know, just pay attention to details.
Okay, that's important in the job you were doing, right?
There.
Okay. And 23, go ahead.
Actually, yes, I also have been part of negotiations in the past for the school district I work with for in the union part. And I'm an intervention specialist, so I write IEPs, and I've had legal training in that.
Okay. So you, the negotiation aspect is on behalf of the unions?
Correct.
Anything about that training and experience that would cause you to favor either side in this case?
No.
Okay. Did I miss anybody? Now, does anybody, and I'll kind of group all these together, have any ethical, moral, religious, or philosophical views that would prevent you from being a fair juror in this case? Juror number 7, go ahead.
I'm a police and prison abolitionist.
A police and prison abolitionist?
Yes.
Describe what that entails.
I don't believe police or prisons should exist.
How long have you held that belief?
Probably came around to that within, maybe 10 years ago.
Okay. Well, if you walked into McDonald's on Richmond Street after you left here, and as soon as you walked in the door, or right before you walked in the door, you saw somebody holding up the counter with a gun, pointing a gun at the worker, and you didn't go in that you went back to your car, would you call the police?
Probably not.
Is there a circumstance where you saw a crime where you think you would call the police?
Only if I thought that somebody's life was immediately in danger and the fact that I couldn't do anything to stop it.
If you were at home and somebody barged in your front door that you didn't know, took a bunch of your stuff and then left, would you then call the police?
I don't think so. They probably needed it more than I did.
If somebody came into your house, barged in, took your stuff and assaulted you, punched you and injured you, when they left, would you call the police?
No.
Now, is it fair for me to assume that if police officers testify in this case that you would be inclined not to believe them?
To an extent.
What would you base your belief or disbelief of their testimony on?
Knowledge of the fact that a lot of times they are trained to deceive in order to get around what they consider roadblocks or obstacles instead of a dead stop in somebody's rights.
So
No offense to the officer present, I'm sorry.
so is it your belief then that part of what the officers do throughout their training and experience is to knowingly deceive people on a regular basis?
Yes, sir.
Will you be able to be fair to the state when they present their case?
I have a hard time believing that I would.
Okay. All right, thank you. Anybody else? All right, now my expectation in talking to the lawyers this morning is this case will probably go no longer than 2 days. And like I said at the beginning, everybody's got work, everybody's got family obligations, things of that nature. But beyond that, beyond those things, is there anything that would prevent anybody from being here for that period of time if you're chosen as a juror? Okay, number
15.
15, go ahead.
If it goes into Wednesday, I have mandatory training for, power plant evacuation.
How long's that been scheduled?
I don't know when they scheduled it for the, local school districts.
Is this something they do in advance of the school year, every year?
Yes, sir.
Okay. Anybody else? 30? Go ahead.
A couple things. This coming Thursday, I have a physical scheduled that was booked back in December, a yearly physical. I canceled blood work today that was scheduled to be here. And then also, when I filled out the application, when I got the subpoena in the mail and went online and did the application, I told them, now that would be week 3. On the 11th, I'm headed to Alaska for a trip that's been planned since like November of last year.
Okay.
So those are things that could be an issue.
Okay, thank you. Anybody else? I saw another hand. 32, go ahead.
I am a hospice RN, and we've been trying to find coverage for me for, I was called maternity leave first in March, and got it deferred from them. Actually, I'm the nurse who fills in, and we have a nurse out on medical leave, and then covering vacations. So I have actually 10 visits on the schedule today, which won't work, the visits take some time. So this is ongoing through the whole summer. I have patients both in facilities and at home who need the RN to look at their point of care and manage what's going on.
Okay, thank you. Anybody else? 26.
I'm a caregiver for my granddaughter, and if I can't watch her, my daughter can't go to work, so she doesn't get paid.
All right, and 11, go ahead.
We do go into Wednesday afternoon, we have a family vacation, been planned about a year, with my family, so I'm good up until Wednesday afternoon.
They wouldn't mind going without you?
I tend to pay for everything, so I don't know how that works out.
Okay. All right, anybody else? Number 10.
I have heart disease, I have a doctor's appointment tomorrow, I have 5 other doctor's appointments coming up here. I'm only here 6 months out of the year. I gotta get this stuff taken care of.
Okay. All right, anybody else? All right, does anybody have any physical problems that would prevent them from sitting for periods of time? And what I mean by that is we'll usually take a break no more than in like an hour and 45 minutes. And you'd have a 15-minute break, and then of course a lunch break. Does anybody have any physical problems that would prevent them from being seated for that period of time? Okay. Now, as I said a while back, it's the duty of the jury to decide whether or not the defendant is guilty or not guilty of these offenses that are alleged. If he is found guilty, it becomes my duty to impose the penalty for that. And I make that decision with the benefit of other facts and circumstances that would not be admissible at the trial, that you would not consider. Does anybody think they can't perform their function of deciding the facts in this case, whether he is guilty or not guilty, without thinking about what might happen if they find him guilty? Number 7, for the reasons you stated previously?
Yes, sir.
Okay, anybody else? Could you just discount the fact that sentencing is not part of your duties? Does anybody that doesn't understand that? Okay. Now, since we've been out here, I came out here about 45 minutes ago. Has anybody formed any opinion on how this case should come out, how it should be decided? Now, in a minute here, I'm going to turn it over to Ms. Linden for the state to inquire, and then Ms. Smith after that for the defense. I want to remind you what they both say or do is not evidence. Evidence is all the testimony received from the witnesses, the exhibits admitted during the trial, facts agreed to by counsel, and any facts I require you to accept is true. Since it's your duty to decide the case based solely on the evidence and the instructions that I give you at the end, you must not consider as evidence any statement or act of any attorney made during the course of this trial, including this voir dire. All right, Ms. Linden?
Thank you, Your Honor. Good morning, ladies and gentlemen. Hopefully you'll all be able to hear me. Sometimes my voice trails off and sometimes I talk a little quickly. So if for some reason I'm not loud enough or I'm talking too quickly, please raise your hand. I will know. Normally it's Kathy telling me or giving me a nod like, hey, slow down. But if there's some time that you don't understand what I'm saying or if I am not loud enough, please let me know. One of the things I guess that I would first address is the witnesses that will be called by the state in this case, and to see whether or not any of you have any knowledge of any of them. One of them will be a woman by the name of Faith Confer. Is anybody familiar with that name at all? If that person comes into the courtroom and you do recognize that person, will everyone agree that they will let the judge know? Sometimes you hear the name, you may not remember the name, but you remember a face. Can all of you agree that you'll let the judge know that if you know somebody? Okay, thank you. And then here, we're dealing with the Painesville Police Department. Painesville police officers are going to testify. You're going to hear and I introduced Officer Belowski from the Painesville Police Department. You'll hear from Officer Joseph Federico, Officer Alexander Grove, and Officer Corey Witt. Are any of those names familiar to any of you? Okay, number 15.
I may have gone to high school with Joe Federico.
Okay, if he comes in here and you see him and you say, yeah, hey, that's the guy I went to high school with, are you going to listen to his testimony the same way that you would with any other witness and judge it accordingly? Okay. The fact that you went to school together, is that going to have
I haven't seen him in too many years.
Okay, fair enough, thank you. Anyone else? What about any of the Painesville police officers? Has anybody had any contact with or know any of the Painesville police officers? No hands? Okay. Oh, back number 35?
That's Cruz.
Vince Cruz?
Yeah.
Okay, and how do you know Vince
High
Cruz?
school.
From high school? And the fact that you know him and you know he works for Painesville, is that going to have any bearing or weight on what your determination is of these witnesses here today? You can be fair and impartial?
Yeah.
Okay, thank you. Now, one of the things that the judge did talk about in some of the questions that we're asking, and I will just say first, there aren't any wrong answers. Certainly, each side wants to have witnesses that are going to be fair and impartial. And I will say that sometimes when people hear cases like domestic violence or strangulation, there is an immediate reaction that some people do have. And sometimes jurors may not be the best for this particular case, but they would be better for another case, and there are reasons for that. Is there anybody here that just knowing the fact that the charges are domestic violence and strangulation, that they would have an issue listening to the facts of this case? Okay, number 15.
I might just because I have daughters. If someone did that to my daughters, I would probably be on that ledge.
Okay, fair enough. In in listening to the alleged victim here come in and testify and the officers, would you listen to what they had to say, listen to the testimony, and be fair and impartial about what was said?
I would do that.
Anyone else? Thank you. Anyone else? Number 3.
I've worked with a lot of reporting parties through the university system, so folks that are reporting assault, and then walking them through the Title IX process from investigation to the final conclusion, which is not an easy thing to do. So it's stressful.
How long have you been doing that?
I did that for about 7 years.
And having someone come in here and talk about domestic violence or strangulation, would you be able to listen to the facts and circumstances and make a determination based on that?
I would do my best.
An additional question, did you encounter through the course of your work with Title IX victims who were not cooperative or didn't want to pursue charges?
So no one in the Title IX process pursues charges. That would be outside of the university system. I have worked with victims who wanted to talk to an investigator, but then when it came time for the investigator to go about the investigation, they said they didn't want that done. I'm not sure how to explain it, but they just said, I don't want my name involved with this. I don't want anybody to know I've reported it.
And in some of those circumstances, if they initially said that they wanted to go forward and they changed their mind, did you have an opinion at all with them about that?
I had to keep my opinions out of it, and I did that. I would ask them, as an advocate, I would ask them some questions, make sure they understood the choice they were making, the consequences or results of that choice, and then support them in that choice. Because in the end, I'm not the victim, so I want to respect what they want.
And in a situation where you have someone who's going to come in and testify, if they aren't exactly thrilled about having to come in now and testify and they were the victim of domestic violence or strangulation, would you be able to sit and listen and be fair and impartial to both the officers and the alleged victim?
I think I would be able to be fair and impartial. I'm not sure how easy it would be to sit and listen.
Thank you. Thank you for being so forthcoming. I appreciate that. Is there anyone besides 15 and number 3? Okay. All right. Now, one of the things that you heard is the word strangulation. So by a show of hands, if you could tell me who thinks that strangulation means putting your hands around someone's neck and squeezing. How many people think that that's what strangulation is? Pretty much everybody. Anyone who has a differing view about what strangulation is? Number 15.
Using a rope, using any form of device.
Okay. All right. So the judge, he talked to you about the fact that he is going to tell you what the law is. He is going to give you that determination. And you're going to need to listen to that. And most people, when they think of that, you think of somebody's hands around someone's neck and squeezing till they can't breathe. If the actual instruction says to you, and I want to read it so that I don't mess it up at all. And then the charge is strangulation, but it's either strangulation or suffocation. It means any act that impedes the normal breathing or circulation of the blood by applying pressure to the throat or neck or by covering the nose and mouth. So that's the legal definition. Is there anyone here who feels that they cannot go listen to that definition and follow that definition? You have your own view of what it is, and that's what you would follow. Is there anyone who's going to have a problem following the law, what the law says it is? So if it's a situation where someone can't breathe and there's pressure to the throat or neck. Is that something that you would have anybody here would have a hard time considering as being strangulation if the hands are not put around the neck itself? No hands? Is there anyone here who thinks that hearing the terms domestic violence and strangulation, that there has to be physical injury? Anybody here who says, look, if I don't see physical injury, that's not domestic violence, it's not strangulation? No one? Here, with domestic violence, the fact is, and the way that it's defined is cause or attempt to cause physical harm. So with domestic violence, there doesn't have to be harm. It can be that someone attempts to cause physical harm. Is there anyone here who has a problem with that and says, well, if it's going to be domestic violence, there has to be some kind of harm, or I can't find that person guilty? Anybody here who feels that way at all? Anyone here who feels that when you talk about physical injury, that it has to be visible? I see some people shaking their heads. Juror number 9. Does it need to be visible for there to be an injury? So there can be injuries without actual visible signs. Anyone here who feels differently? All right. Anybody here have any medical training? Question that nobody. Okay, medical training back here. Okay, number 15.
I was in the military, I did basic other 3 years, about 2 years. My wife was a physical therapist, so I picked up quite a few.
Well, thank you for your service. And knowing that information, and in this particular case, if there isn't anyone who comes in, no medical personnel, and it's simply a witness and officers coming in to testify, would you be able to listen to that without medical evidence?
I would, yeah.
Number 32 was hospice.
I have a BSN nursing, been at this for 45 years. I did 20 years of critical care on helicopters, and then the last 20 years as hospice.
Thank you for lots of training. Okay. Goes without saying. If we have someone who comes in here and talks about what happens here and there aren't any physical injuries, is there going to be an issue with that, knowing that this is a domestic violence strangulation case?
No issue.
Could you be fair and impartial?
Yes.
There's a in that corner, number 28. LPN. Okay. And as an LPN, what kind of patients do you deal with? Children and elderly. And do you come in contact with any domestic violence or strangulation cases ever? No. Any specialized training in that area? Okay. Do you think that you could listen and be fair and impartial here today? Thank you. Anyone? I saw a couple hands up here. Number 17.
Retired firefighter, paramedic.
And so, as a firefighter paramedic, you do have some specific medical training. Have you responded to, as a result of that, individuals in domestic disputes or strangulation at all?
Yes.
And in those circumstances, were there always injuries?
Usually.
And in this particular case, if there aren't any visible injuries, are you going to have an issue with that based on your medical training?
Don't think so.
And you think you could be fair and impartial, listen to what's said about what happened?
Yes.
And then number 19.
I was a medical assistant, like over 30 years ago, worked in a pediatric doctor's office for about 3 years.
And anything in that training, similar question to what I asked number 17 about domestics or strangulation, any specific training in that area?
No.
And do you think you could be fair and impartial, listen, even if there isn't any medical testimony?
Yes.
Well, that's another question then. In terms of medical testimony, is there anyone nurse in this case, I'm not gonna be able to say that there was a cause or an attempt to cause physical harm. Anyone here who would require medical testimony? No hands? Anyone here who, as soon as they heard the charge, domestic violence and strangulation, they kind of went, ugh? Okay, juror number 4.
Just stressful thing to hear.
Stressful being here.
It's just stressful to hear.
Stressful to hear.
To think that.
Knowing that you're going to hear testimony from someone and you're going to hear testimony from officers and that that's going to be discussed, do you think that you'll be able to sit here and listen and be fair and impartial to the witnesses that testify?
I think it would be difficult.
Difficult in terms of not being able to listen, or difficult in terms of trying to make a determination? Do you feel that you could sit here and be fair and impartial, listen to what each person says?
I could. But it would be difficult.
It would be difficult.
It would be difficult to process.
Thank you for your name, I appreciate that.
Basically the same, it's hard to hear. I have 2 daughters, you know, when you hear something like that happening to somebody, it just, I wouldn't have any problem with being impartial with what you're asking. But it's just hard to hear those kind of charges, you know.
Well, the defendant, as he sits here, everyone can agree, there's been no testimony about anything at all yet. And you need to hear testimony from witnesses, you need to hear something from this stand here to people who are under oath talking about what happened. In terms of listening to that testimony, do you think that you would be able to listen to each person and say, well, do I think they're telling the truth or not? Do I believe that this happened or not? Do you think that you both could do that? Thank you. Another hand? Number 15.
Same thing as Salem.
Thank you. And listening to each of the witnesses,
I would do my best.
what about if you have?
Hold on 1 second. Let me address number 15 real quick. If,
Yes, sir.
let's say that somebody accused you of the nature of that offense, okay?
Yes, sir.
And you had no idea what they were talking about, and you didn't do it, okay? And you said, well, I didn't do it, so you end up at a trial.
Yes, sir.
Do you want jurors that would consider your case based on the evidence and based on the law that they're given? Or do you want them to make an assumption that you did it?
I would do my best to listen to the items that are put out towards
Right.
me, and I would hope that the jurors would do the same. And like I said, I have daughters, and if my daughters were attacked by that, or something like that, like my daughters came in and said, so-and-so did this, I may have a difficult,
Well, I think everybody who's in your situation would have a kind of a visceral reaction of that and wouldn't like it, okay?
Yes.
But there's also the requirement, unlike the gentleman who was on grand jury in the past, it's the obligation of the jury to listen to the evidence, evaluate the evidence, and decide the case, and decide if what is being said is proven by the state beyond a reasonable doubt. So ultimately, the only really question here is whether you could listen, evaluate, and follow the law.
I would do it to my best ability.
And nobody expects anybody to do anything other than to the best of their
Yeah,
ability.
That's all, that's the
All right.
best answer I can give.
Okay, thank you. Go ahead.
And touching a little bit on that, the state knows that its burden is to prove the case beyond a reasonable doubt. We welcome that. We want you to listen to the testimony. We want you to make a determination based on what you hear. But I do know that there are people in there, and I don't specifically say anybody unless you want to talk about it, that don't like attorneys and think that attorneys all lie, think that attorneys are no good. There are those opinions, and I understand that out there. Here, it's not a matter of whether you like me, whether you like Ms. Smith, but whether or not listening to the testimony, the state proves its case. So for those of you who don't like attorneys, think that we're maybe dishonest, is there anybody here who couldn't set that aside, who couldn't listen to what the testimony is, what these people say, to make their determination? Is there anybody here who couldn't do that, just listen to what these people are saying here? Despite the fact that I'm a lawyer, Ms. Smith's a lawyer, Mr. Knopf's a lawyer, anybody here would have a problem with that, knowing that you don't like lawyers? In this case, we probably have one of our witnesses who doesn't like lawyers. Victim, in this case, may not be particularly happy with lawyers. If that's the case, would you still be able to sit here? Is there anybody here who could not sit here and be fair and impartial to the state, even if the witness is not happy with me? Anybody here, by show of hands, that would not be able to sit here and listen? Anybody here, I guess I'll throw this out there. Is anybody here who just really just doesn't want to be here? Doesn't want to be a juror? I mean, it's okay. Okay. And the
Well,
reason.
it's okay, but it's not okay. If we had, because as a general rule, whenever Bob, it's not my fault, it's Bob's fault. Whenever he tells 45 people they have to be there, generally, a vast majority are unhappy because it disturbs their routine. But that doesn't matter from the standpoint that we don't have people show up, and we don't have a system. So go ahead, Ms. Lynn.
Is there anybody who doesn't think that the defendant in this matter has a right to have a fair and impartial jury? Along the lines of the question that I asked you, is there anybody here who says, you know what, I probably wouldn't even be a good juror on my own case. I don't think I'd be a good juror. I don't know that I could do this. Is there anybody here who feels that way? Just, I don't, for the same reasons you stated already?
Yes.
Number 7, number 2.
I don't feel confident because I don't think I'm smart enough to understand everything that's on there.
Yes, you are.
Well, you are. And one of the things that, I guess the beauty of having this many people here is that you all are different. And you all bring different things to the table. So knowing that you're going to be with a group of people and you're going to be able to discuss the facts of the case, and you all have input in this, do you feel that you would be able to make your own individual decision based on what you hear and based on your life experiences?
I always felt like you said, there's gonna be police officers testifying, right?
Mm-hmm.
I always felt that I always respected police officers. So I figured, in a way, I probably would feel like they're right before other witnesses, you know what I'm saying?
What if they came in, or what if the first one came in here and testified and Ms. Linden said, what's it look like outside right now? And the police officer said, well, there's a tornado out there that just destroyed that building across the
That's a
street.
different story.
Okay, but it's an absurd comparison, except, you're retired now, right?
Right.
What did you do for a living?
I drove a truck and make deliveries.
Okay, and when you made deliveries, you delivered to somebody, right?
Right.
And you talked to them.
I delivered to the sheriff's department here.
Okay. So when you did that, you dealt with people, right?
Right.
And you've had a lot of experience over the years in talking to people and knowing if they tell you something it doesn't ring true or it does ring true, right?
Right.
Okay. I mean, police officers are no different than anybody else, and and one of the instructions I'll give you is you're to treat them the same way as everybody else, okay?
I always respected them, I said.
That's fine. I mean, most people respect them,
I
okay?
respect what they do, and I feel like I wouldn't make the wrong decision. That's
Okay,
all I'm saying.
but do you realize they're not infallible? They can make mistakes. Do you understand that?
Well, I understand that. I had a bad experience with the last. I had an accident where a lady hit me, and I had a bad experience because the officer didn't make the right report or anything like that, and he let the lady go with the.
Okay.
Ran the red light, pickup, ran over the double lines and she was on the phone. And the officer said, I'm not gonna give you a ticket. Said that-
Other than that, she was a great driver. So-
Because that's because I'm not.
Okay, so your evaluation of that situation is that the officer was wrong.
Right, I mean,
Okay.
I respected him for what he does, but I think he made the wrong report.
Okay, so if you sit here and you listen to the testimony and you respect the officer, but you think he was wrong, would you be able to decide the case based on the testimony?
I would say yes.
Okay,
Then again,
Well, juror number two, you have two kids, right?
three.
Three.
I mean, two, yes.
Oh, two,
See,
two.
short memory.
It's okay, that's okay. You have two children, and well, have they always told you the truth? Okay, it's a tough question, but when you're looking at your kids and you're trying to make a determination, what are the kinds of things you look at to determine if they're telling you the truth?
Sometimes, how should I put it? I mean, you can look at, you can tell if they're telling the truth or not, you can tell, because they're your kids, you know what I'm saying? But I'm not saying they've always been honest with me, but.
And you have, do you have other family members in your own family? Do you have brothers and sisters?
I got a sister, well, actually, I got a sister in Australia, one in Italy, and one in somewhere in Pennsylvania.
And with those individuals, if they're talking to you, telling you stories, are you able to listen to what they're saying and say, I don't know if I really believe that, or maybe they're embellishing a little, or, okay, that's true?
Well, like my brothers, they passed away already, but anyway, one of them I could tell when he was telling the truth, but the other one I could tell when he wasn't.
Okay. So you were able to look at what they were saying, how they were saying, and make a
Right.
determination. Do you think that having the witnesses up here on the witness stand, you can do the same thing? Watch their body language, watch what they're saying, listen to what they're saying, and make a determination if you think that they're believable?
That's tough to say, I would have to listen, but then I would know, I'm not sure if I would make the right decision. But,
Would you listen and be fair and impartial
I
to what
would
you're saying?
definitely listen, but,
No, I appreciate that, thank you. Anybody else who feels the same way? All right. One of the things that you see in the news all the time, and one of the things that I have heard from juries before is if it's not on video, it didn't happen. Is there anybody here who believes that? If it's not on video, it didn't happen? Okay, no hands. Okay. How many of you think that domestic violence is always out in the open? No hands. How many of you feel that domestic violence sometimes happens in the home where nobody sees it? Okay, a lot of hands. Okay. So is there anybody here who, if I don't have a video of what happened, is going to say, well, if you don't have a video, I'm not going to be able to find you guilty? Anybody here who feels that way? Now, I know we all watched CSI and Court TV and shows like that. Everybody understand that offenses are not solved in an hour. We don't have computers that just spit out a photo of somebody that they did it. Everybody understand that that's not the way things really are. You get to see firsthand what excitement you have in a courtroom. Is there anybody here who, looking at what happens on TV and the evidence that's needed on TV, that you're going to hold the state to a higher standard based on that? That you're going to expect more from the state of Ohio based on what you see and hear in the news, on TV? And the last thing that I want to address is, and the judge touched on this a little bit, but there are rules in the courtroom. And the rules in the courtroom sometimes will mean that you'll hear the word objection from me or from Ms. anybody who feels that that would be the case. If there's objections that we're hiding something. Okay, anybody here who can agree, who would agree with me that if there's an objection, there's a legal reason why a question can't be answered? Is there anybody here who does understand that? Who understands that if there's an objection, there might be a legal reason why we can't talk about something? I appreciate your attention and time. I am this time.
All right, thank you.
Thank you.
Ms. Smith?
Good morning again. I'm Rachel Smith. I am one of the attorneys representing Mark Jackson in this case. So I'm going to be the third person talking to you. That is how things are going to go throughout the day, throughout the trial. I'm always going, myself or my co-counsel will always be the last one to talk. That means we sound unoriginal a number of times. It means that a lot of times we have to take you through things that you've already heard, because we need you to look at them a different way. Is there anyone here that might have any issues with attention, that would have difficulty hearing something for the second or third time and giving something that they hear later in the day the same weight that they might give something they hear earlier in the day? No? All right. Did anyone here, when they walked in to court, take a look at my client and think to themselves, what did he do? No? Glad to hear it. What kind of reaction do you have when you are driving down the road and you see a car pulled over? Do you wonder what happened? Number 6, you were nodding your head. What things do you wonder when you drive past a car that's been pulled over on the side of the road?
How fast were they going?
Okay.
That's my natural assumption, because it might have been me.
All right, and even though you first think, how fast were they going? Do you understand that sometimes people are pulled over and they aren't accused of speeding?
Yeah, I guess so.
And that sometimes law enforcement officers use something other than a radar gun. They may be pacing, and they estimate a speed, and sometimes they might be wrong.
It's a possibility.
So when you wonder how fast he was going, are you wondering what he did because he must have done it? Or are you wondering what might have happened?
For a second or two, maybe once I get past was like, oh, they're in trouble.
Sure. What might have happened is the question that we need you to be asking today. Now, what did Mr. Jackson do? But what happened? The case that you guys are going to hear is somewhat unique in that there are only 2 people who know what happened on the January 1st of 2025. Mr. Jackson has a right to remain silent. So you're going to hear, and if he chooses to invoke that right, you will hear one side of the story today from 2 people in the room, 2 people who know what happened. One person's going to say their side of the story. Would you have any difficulty not attributing Mr. Jackson's silence to some evidence of guilt? Nobody here believes that if he didn't do it, he would say something. When you're accused of, have any of you ever been accused of, not a crime, but perhaps lying to your parents? And when your number 3, you were nodding, for sure. When your parents accused you of lying as a child, did you just sit there quietly?
No,
What was your first instinct?
to make an argument.
To defend yourself?
Sure.
So Mr. Jackson is defending himself. That's why he has 2 attorneys. We are here speaking for Mr. Jackson so that he doesn't have to give up his right to remain silent. And that's a right that each of us have, and it is one that the defense attorneys across the country advise people generally to hold sacrosanct. is, let's see, talk about, a little bit about the burden of proof. So in criminal court, we talk about the burden of proof, which is proof beyond a reasonable doubt. Anyone here have an idea of what that means? If you don't raise your hands, I will cold call. All right. Juror number 10. What does proof beyond a reasonable doubt mean to you? Well, if you don't know, then I'm glad we're talking about it, because that's something that you, if you're part of this jury panel, are going to be asked to decide. Has the state met its burden? And its burden is proof beyond a reasonable doubt. Well, in addition to the presumption of innocence and the burden of proof, another constitutional guarantee that Mr. Jackson has is a jury of his peers. Now, if we look around the room, a constitutional meaning of peers cannot mean people who look like you. There is not any individual in this room who shares the same demographic background as Mr. Jackson. So if peers means looking alike, then he can't have a constitutional trial. So we know that peers means something different. What does peer mean to you? Number 7.
Somebody on the same power level in terms of how like state power is designated.
Could you explain that a little bit?
We're on equal footing as the defendant in terms of what rights we have, and
You've got the same rights. That also means that if you were accused of the same thing, how much evidence would you want the state to have to present before you were convicted of a crime? So having a jury of your peers and the constitutional burden of proof, if what the state has not presented would satisfy proof beyond a reasonable doubt if you were the defendant, then can you return a guilty verdict? If you didn't think that the state presented enough evidence to convict you in that position, can you return a guilty verdict against Mr. Jackson? I see a couple people shaking their heads no and a few people looking confused. But I'd like to know what you guys think about that question. Is there anyone in this room that might require less evidence to convict somebody sitting at the defense table simply because they're behind the defendant's table than they would if they were sitting there? Okay. So everyone here will be able to hear the evidence, and then when they're weighing the evidence that they've heard, return the same verdict for Mr. Jackson that you would desire a jury in your case to return for you based on the evidence. Obviously, we all want a not guilty verdict. We're sitting behind the defendant's table. All right. Let me talk a little bit more about burden. Do we have any sports fans here?
Baseball.
Baseball? Do you have a favorite team?
The Guardians.
Okay. Do you have any Guardians merch? Do you, when you go to a game, do you wear a jersey or a t-shirt? Okay. What is your least favorite baseball team?
Probably
The Yankees? All right. So if you were at a game and you were watching the Guardians play the Yankees, and you're there and you're sitting there in your Guardians jersey, how many things would have to transpire in that game to make you take your jersey off and put on the jersey of the other team?
I would not put on the Yankees jersey, but I would also wouldn't take the Guardians jersey off.
All right.
It may make me upset, but I'll still walk out of the stadium with my jersey on.
Well, we're kind of sitting here, people look at trials as one side against the other, much like sports. And we have teams here. So right now, I consider myself part of Team Innocence. client is cloaked in the presumption of innocence, all of you are also a member of Team Innocence. So as you sit through this trial and you think about the weight of the evidence, the burden of proof, what I'm gonna ask you to do is think, have they presented enough evidence to get me to change my team? It must be compelling. Now, we talked a little bit about burden of proof and the burden being on the state of Ohio. And the assistant prosecutor has indicated they're very comfortable with holding that burden. Because of that, I could stand here silent. I could not talk to you now. I could ask no questions throughout trial. Same with my co-counsel. We could call no witnesses, present no exhibits. Would you be able to consider that Mr. Jackson is not guilty? Would anyone hold it against Mr. Jackson if his attorney presented no evidence on his behalf? No? We've already established that Mr. Jackson doesn't have to testify, doesn't have to put on a case. I want to talk a little bit about the subject matter of this case. A couple of you have indicated that you'd have discomfort around the charges that are alleged and the facts that might come out through testimony because of your own kids or your own circumstances. The juror questionnaire also talked a little bit about each of your own prior experiences, and I know that some of you did indicate that you have some previous trauma in your history. So without trying to pry or embarrass anybody at all, I do want to talk about the subjects of post-traumatic stress disorder and then also intimate partner violence. Anyone here ever been the victim of, or know anyone who's been the victim of domestic violence? Number 3. Is this something that you're comfortable talking about in front of everyone, or would you prefer to talk about it one-on-one with the judge?
I can talk about it a little bit, but there's confidentiality around the cases I've dealt with at the university.
Understood. We will not ask you to break any sort of confidentiality. And you've discussed a little bit about how your work and the work that you've done might make it difficult to hear these things. Is there anything that you need to add to the prior discussion? Okay. Does only one person in this room? Oh, I'm sorry, okay. Now, your experience with intimate partner violence.
It was
Domestic violence. And is that going to make it difficult for you to be able to listen to the evidence in this case? Is it going to be difficult for you to consider the potential of Mr. Jackson being not guilty?
I'd like to say, like, the crystal ball first, because, there's 3 sides to every story. Their side, the other side, and the truth. So I'm trying to figure out the truth from all the different evidence.
Go ahead. Number 12.
I dated someone 34 years ago who was not a nice person.
I'm sorry that you went through that. With that being such a personal experience, would you have difficulty considering that somebody accused of domestic violence might be not guilty of that?
No, that would be fair and impartial.
Does anybody here have any experience or familiarity with mental health disorders? Juror number 33. Thank you. Can you share a little bit?
My sister was severely depressed, and even though we tried to help, this past February, she committed suicide.
I'm sorry to hear that. Anything anything about that experience that might make it difficult for you to weigh the evidence fairly against, where somebody is accused of causing harm to somebody with mental illness? No. Anybody else with their hands up? Juror number 23? Am I saying your name? Yes.
Oh, sorry. Oh, my gosh. Sorry. Yes, I have family members with anxiety and depression, and I have a family list.
And because of the struggles that those family members have, does that impact your relationship with them at all?
One a little bit, because they're more closer than the other, but just because it's like a joint family that I take care of.
Who else had their hand up? Number 21.
Kind of the same thing, I have family members I'm close with schizophrenia, depression, anxiety.
And when you are interacting with somebody with schizophrenia, which is a severe mental illness, does it change the way that you engage with them?
No, I think you just, I have to have a little more patience perhaps, but, no, that's just part of the person.
Do you have any difficulty either discrediting or disbelieving that person in your life because you're aware of their illness?
No.
No. Number 15. You had your hand up?
Yes, ma'am.
Anything?
Anxiety, depression, narcissism, things like that.
Okay. Have those experiences been frustrating for you?
Oh, yes.
Okay. Do they change the way that you engage with people?
At times.
Okay, those individuals specifically?
Those individuals or people, there's sometimes, I weigh everything with a grain of salt. I don't think everything personally. Yeah.
Now, I'm sorry, before I move on to the next question, was there anybody else that had their hand up in regards to that question? Number 30.
My dad is like, I don't know what it technically is, but he's like crazy. He planted a fake bomb
Okay.
in Pennsylvania. So, and he's always been a liar, so people with those kind
Okay.
of problems.
So based on your experience with your father, do you have a tendency to disbelieve people that you may know have a serious mental illness?
Yes.
Is that something that you would be able to set aside when
It'd be tough.
listening
It
to?
was like a cornerstone of my life. So it'd be really, really difficult. Yeah.
Now, your father's an extreme example.
Yeah.
Would it,
Yeah, but it's extreme, but it had a big impact.
okay,
So,
so you,
dealt with it, my whole life.
so do you believe that you would be able to set aside your feelings towards your father and fairly consider the testimony regardless of who it is offered by?
Good question. I wouldn't be confident.
Okay. I appreciate your honesty. Okay. I know a number of you have family members and friends that are law enforcement, and one of you is retired law enforcement yourself. If you were to return a not guilty verdict in this case, would you have difficulty talking about your experience or explaining it to your law enforcement family members or friends? No? Does the fact that you have family and friends who are in law enforcement impact your impression or attitude towards people who are charged with crimes? No. All right, because I'm not going to make you re-listen to everything that you've already gone through this morning, I'm gonna wrap that up here. Next, we're gonna be selecting who's on the jury. I wanna make sure that everybody who had something that they wanted to share had the opportunity to share that. Is there anybody here who has an experience or feeling or belief that would impact their jury service that we have not asked any questions about? Thank you.
Thank you. All right, at this time, ladies and gentlemen, I'm gonna meet with council. We're gonna select the 13 people who will hear this case. I'll ask you guys to go out in the hallway. When you go out in the hallway, you can talk to each other about anything you want, with the exception of everything we just talked about now. Okay, so leave those subjects alone. Go talk to your old acquaintances a little bit more, and then Bob will round you up. Probably, I would anticipate about 20 or 25 minutes, we'll be back in here, all right?
All right, Victor.
You can file out, just go ahead. Okay, have a seat. All right, cause for the state.
Number 7, Your Honor.
Ms. Smith, any comment on 7?
Only that it was expected.
Okay. All right, 7 excused. Anybody else?
No, Your Honor, I'd pass for cause.
Ms. Smith, any for cause that you see that you want to excuse?
No others for cause, Your Honor.
All right, well, okay. Now, number 10, the one with the heart disease, has an appointment tomorrow, so I'm going to let him go for cause. Number 11's going on vacation Wednesday, and I don't want any hiccups that he ain't going on vacation, so I'm going to excuse him for cause. See, and if 10 and 11 would have said that to Bob last week, they wouldn't be here right now, so. 15 has got this training at the power plant. I'm going to excuse him. '26, is a caregiver for her granddaughter, and that's the only one she has, and the daughter can't go to work. I'm going to excuse her. '30's got his physical scheduled that if he doesn't, and again, it's Thursday, but you never know. If he doesn't get there, he's not going to get it for another year probably, so I'm going to excuse him. And the hospice nurse, I'm also going to excuse. And if with those 10, 11, 15, 26, 30, and 32, had those people indicated that in advance of today, they would all have been excused. All right, so I'm going to give you guys a few minutes, and consider your peremptories. Like, let Bob know when you're ready, and then I'll come back in. Okay?
Your Honor, could you give us those numbers again? Just
Yeah.
Just to make sure I have
10.
them. Okay, 10.
Well, 7, 10, 11, 15, 26, 30, 32.
All right, thank you, Your Honor.
the whole, when you see us in the halls, we're not saying anything, we're not being rude, but.
Issues for peremptories.
You actually have to go that way.
So with who's left over, 1 through 25 are the only road changes. This is the one that we said no right here.
Sorry.
11. So we have 26. 32. Second positive towards the He's no, it doesn't matter, we just did say that to the whole group, so I'm trying to look at it. So she's out. 30's out. 26 is. So 15, Scott had 15 on.
He's out.
So he's out. So that means.
It's interesting here, when you hear people really speaking, you get a better sense.
Is
That's like,
anybody that we
number
saw
2, I
in
wanted to get rid of him.
around it? That was like, no.
He was the one with
Oh my God.
the discusses. But
I'm just trying to figure out who the,
I mean, I liked his vibe in general. Yeah, he was like, listen, I feel like it's unofficial. No way. Their house. Not really.
We'll see what we have him. He's the,
I'll give this speed up, just draw.
the only thing is this is shaking.
30.
39 and 28.
So I would say.
39 and 22.
on that
Okay.
one.
The 38 subbed in as 10.
And then
38 did, yeah.
So that guy was excused.
this is the 38. So 38 is.
No.
Yeah, he was the very close to 32.
Okay.
Right?
Yeah.
Or maybe number 4? Or he was number 10.
No, he replaced number. Favor is what number?
It was 38.
So he's 38, so I think 38.
But 10 is out.
37.
He left the call. But he was replaced as number 10.
Worried about how
Okay,
close it's getting
so,
close.
yeah, he was number 10. Okay.
How many, 3 or 4 from the bottom, or just
So
2?
we don't want.
Well, remember, all those
Don't
people
like
from the
this.
end got slid in.
Yeah.
That's the. No, oh, he's Croatian. Doesn't trust the system, ex-wife's a narcissist, hates the courts. So I'm saying, that's his name, most likely. Did he become 34?
much longer do you need, Counselors?
About 5 more minutes?
Okay.
That's the best one.
Okay, we just finished questioning the jury and have to see if the jury was and then if they were testifying. You can tell Federico and Grove that they can come back in about an hour.
Anybody answers that question, that automatically is strike for me unless something crazy happens. It just indicates
If
such
it takes
a
until lunch,
pro
then
prosecution
after lunch, I'll let you know for sure.
And
We'll
anyone
probably
who's
pick
criminal
that.
is incapable of at
They're not
least
gonna be
So if they
full-
contemplating.
can't contemplate wrongful convictions, so they can't
That's good.
contemplate innocence usually.
And she said that she was
Wrongful
going to audio
convictions
for.
and getting it wrong.
She's aligned with them. She doesn't believe that there's any audio of her. She was surprised. Mark is not testifying. Yep, you go out to the right, all the way straight down to the end of the hallway, you'll see it. The doors to the right. I'm gonna suggest you go on the floor above, just in case there are jurors. So, just in the same spot.
But couple people are already gone. Guy you mentioned come back, he's gone. The one, we had a couple doctors appointments and stuff, he's gone. And then we'll get the strike three, strike three too.
Cross the page before lunch. We still gotta seek the jury preliminary instructions. And the state's cross is gonna be more than an hour.
Yeah, you think?
Taylor?
Yeah.
Well, you have no idea, how long your cross of faith is gonna be, because it largely depends on what she says.
Right, since she doesn't think there's any audio, it's probably gonna take a little while because I have a lot of audio for to play of her talking, so. Okay, it's gonna take a little while.
All set, Counselors?
Yes.
Okay. We're just waiting on,
Officer.
Officer Pulaski?
Yes.
All right.
I had him go up to the floor,
No problem.
I should go to the bathroom or?
yeah, he had to use the restroom, so.
Are you ready?
Yes, Your Honor, yes.
All right, first the state.
It would, juror number 24.
Okay, defense.
Juror number 12.
State.
Juror number 28.
Defense.
Juror number 4.
State.
I think he's still 35. Christopher Lowe.
Okay, defense.
22.
And state.
I don't think we'll get there, but 39.
Oh, they're all out. 30, it only goes up to 36.
Dennis.
He's,
Is he not?
he's 34.
34, yeah, that's what it
Okay,
is.
defense.
Pass.
Okay, so count along with me. The 12 are 1, 2, 3, 5, 6, 8, 9, 13, 14, 16, 17, 18. Do I have that right?
Yes.
Yes.
It's 12. It would make 19 as the alternate. Is there a excusal from the state on 19 for the alternate?
No, Your Honor, we passed.
On the defense?
Pass.
Okay, so 19 will be the alternate identified at the end. Either of you had that stipulation?
No, Your Honor.
Does Ray have judge?
One, two, 5, 6,
And then I'm gonna send you to lunch right after that, so it'll be a little bit of an early lunch, and then we'll come back in about an hour and begin with the testimony. All right, evidence is all the testimony received from the witnesses, the exhibits admitted during the trial, facts agreed to by counsel, and any facts which the court requires you to accept as true. Evidence may be direct or circumstantial or both. Direct evidence is the testimony given by a witness who has seen or heard the facts to which he or she testifies. It includes exhibits admitted into evidence during the trial. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may reasonably infer other related or connected facts which naturally and logically follow according to the common experience of mankind. Direct evidence and circumstantial evidence are of equal weight. The evidence does not include the indictment or opening statements or closing arguments of counsel. The opening statements and closing arguments of counsel are designed to assist you. They are not evidence. You are the sole judges of the facts, the credibility of the witnesses, and the weight of the evidence. To weigh the evidence, you must consider the credibility of the witnesses. You may apply the tests of truthfulness which you apply in your daily lives. These tests may include, but are not limited to, the appearance of each witness upon the stand, the reasonableness of the testimony, the opportunity to see, hear, and know the things concerning which they testified, the accuracy of memory, frankness or lack of it, interest and bias, if any, together with all the facts and circumstances surrounding the testimony. Applying these tests, you may assign to the testimony of each witness such weight as you deem proper. You are not required to believe the testimony of any witness simply because they were under oath. You may believe or disbelieve all or any part of the testimony of any witness. It is your province to determine what testimony is worthy of belief and what testimony is not worthy of belief. The testimony of a defendant is to be weighed by the same rules that apply to other witnesses if the defendant takes a stand and testifies. The defendant has the Fifth Amendment right to not testify in this trial. If the defendant chooses not to testify, you shall not consider that decision for any purpose. You should not decide any issue of fact merely on the basis of the number of witnesses who testify on each side of an issue. Rather, the final test in judging evidence would be the force and weight of the evidence regardless of the number of witnesses on each side of an issue. The testimony of one witness believed by you is sufficient to prove any fact. During the course of this trial, a number of exhibits and testimony relating to these exhibits may be introduced as evidence. You will determine what weight, if any, the exhibit should receive in light of all the evidence. Jurors will be permitted to take notes during the trial. Jurors will not be permitted to ask questions of witnesses. It is the responsibility of the lawyers to present all the evidence necessary for you to decide the issues in this case. You will not be permitted access to transcripts of witness testimony during your deliberations. Please be aware that once deliberations have begun, you may not have contact with anyone other than your fellow jurors and the bailiff. This means that once deliberations begin, you will not be able to make any phone calls. We'll give you advance warning when we're getting close to the end of the case, so you may wish to let the necessary people know that you will be out of contact once the deliberations begin. You can be reached for emergencies, but if you are called out of the jury room, you will not be able to return. It's important that you be fair and attentive throughout the trial. Do not discuss the case among yourselves or with anyone else. Do not permit anyone to discuss it with you or in your presence. Do not form or express any opinion on the case until it is finally submitted to you. Wear your lanyards, the IDs, so that the attorneys, the parties, the witnesses know that you are jurors and off limits for conversation and contact. It may be difficult for you to understand why you may not discuss this case among yourselves until it is submitted to you. You will receive the opening statements, the evidence, the instructions of law, and then the arguments of counsel. It would be unfair to discuss the case among yourselves before you receive everything necessary to reach an informed decision. You should explain this rule prohibiting discussion of a case to your family and friends. When the trial is over and your duty is complete, you will be released from this instruction. At that time, you may discuss the case and your experiences as a juror. I'm going to give you what is called the admonition. It's a standing court order that applies throughout the trial. I'll try to remind you of a version of it at every recess, but if I forget, it still applies. You have been selected as jurors in this case. We have taken the time to seat a neutral jury so this case can be decided based just on what goes on in the courtroom and not on outside influences. You are required to decide this case based solely on the evidence that is presented to you in the courtroom. It is my role as a judge to determine what evidence is admissible and what evidence is not admissible. It would be a violation of your duties and unfair to the parties if you should obtain other information about the case, which might be information that is not admissible as evidence. You must carefully listen to all the evidence and evaluate all of it. Do not reach any conclusions until you have heard all the evidence, my instructions of law, and the arguments of the attorneys. Otherwise, you will have an incomplete picture of the case. Do not discuss this case among yourselves or with anyone else. The reason for this is you might be given information or an opinion that could alter the way in which you view the evidence or the instructions or even how the case should come out. Such an opinion or conclusion would be based on an incomplete or inaccurate view of the evidence and therefore would be clearly unfair. In addition, you must not try to get any information from any other source. This ban on outside information also includes any personal investigation, including visiting the site, looking into news accounts, talking to possible witnesses, reenacting the allegations in the indictment, or any other act that would otherwise affect the fairness and impartiality that you must have as a juror. Finally, you must not have contact with anyone about this case other than me and the court employees. This includes viewing any social media sites of any kind regarding this case or any aspect of your jury service during the trial. If anyone tries to contact you about the case directly or indirectly, do not allow that person to have contact with you. If anyone persists in contacting you or speaking with you, that could be jury tampering, which is a serious crime. If anyone contacts you in this manner, report that to me or to the bailiff as quickly as possible. You should know that if this admonition is violated, there could be a mistrial. A mistrial means that the case is stopped before it is finished and must be retried at a later date. This can lead to a great deal of expense for the parties and for the taxpayers. If a mistrial were to be declared based on a violation of the admonition, the juror responsible could be required to pay the cost of the first trial and also could be held in contempt of court. All right, before we get to the opening statements, I'm going to read you stipulations that the parties have made in this case. That means they're not going to have to prove those factors. They're agreeing that they're true and you're to accept them as true. All right, with regard to count one, the defendant stipulates that he, Mark Jackson Jr., was previously convicted of or pled guilty to a felony offense of violence in the Cuyahoga County Court of Common Pleas, case number CR 21-659-273, dated July 20 of 2021. As to count two, the parties stipulate, the defendant stipulates that he, Mark Jackson Jr., was previously convicted of or pled guilty to domestic violence in the Cuyahoga County Court of Common Pleas, case number CR 21-659-273, dated July 20, 2021. Number three, the parties and the defendant stipulate that the alleged victim, Faith Confer, that he and Faith Confer were in a dating relationship at the time of the offense as defined in Ohio Revised Code, section 3113.31. Fourth, the defendant and the parties agree that the alleged victim, Faith Confer, that they were family or household members at the time of the offense as defined in Ohio Revised Code section 2919.25. And lastly, the parties agree that the identity of the defendant, Mark Jackson Jr., the date of the alleged conduct, which is on or about January 1, 2025, and this jurisdiction of the Lake County, jurisdiction of the court, that being Lake County, Ohio, are all stipulated to and are all facts. So each of those stipulations are to be taken as facts by you when you get to the end of this trial. Anything you want to add to that from the state?
No, Your Honor, thank you.
Defense?
No, it's not, Your Honor.
All right, we're going to begin with the opening statements. And remember, the opening statements are not evidence. They're a preview of the claims designed to help you follow the evidence as it's presented. Ms. Linden?
Thank you, Your Honor. you keep comparing me to your ex, then I'm going to abuse you like he did so that you can say that I abused you. That's what the defendant said to Peyton Hopper on January 1st of this year. He said that because they had been arguing a little earlier in the day over a Facebook page, a Facebook message on the phone. That led to the defendant getting angry with Faith. That led to the defendant continuing to bug her, continuing to talk to her, to the point where Faith walked into the bedroom, sat down on the bed. She just wanted to be left alone. The defendant wasn't going to do that. The defendant came in the bedroom, pushed her down on the bed while their small infant child was laying on the bed, crossed his arms up underneath her chest and neck, and put all of his weight on top of her on the bed, to the point where she could not breathe. She said she was seeing blurs. She asked him repeatedly to get off her. She couldn't move because her child was right next to her. She was really having a hard time breathing, but that didn't matter to the defendant because as I just said, he said he was going to treat her just like her ex did and abuse her just like her ex did. He knew about Faith's prior relationship. He knew about the extent of that relationship and how terrifying that was and how she had some PTSD as a result of that. But he didn't care. He continued to hold her down. He continued to have his arms across to the point where her voice was raspy and she was upset and she was afraid. She finally determined that if I calm down and I just kind of sit here, maybe he'll get up and leave me alone. And eventually he did. And at that point in time, Faith went into the bathroom. She knew she couldn't call 911 because she couldn't talk because the defendant was there. So what did she do? She texted 911. She didn't think it went through, but it did. Dispatch called back. Dispatch said, "Is everything okay?" And her response was no. As a result, several Painesville officers within 5 minutes were at the apartment. When they came to the apartment, you're going to hear, they knocked on the door. Faith didn't come to the door right away. They knocked again. They hadn't even announced that they were police. They just knocked on the door. She finally came to the door and she opened the door. But she didn't open it all the way. You'll hear from the police officers that they could tell by looking at her that something was wrong. And although she said she was just kind of going through things, they knew that there was something more. She seemed very upset. And she continued to make motions with her eyes, kind of pointing over to the door. You're going to hear that one of the officers said, "Is he behind the door?" Whispered it or mouthed it, and she nodded yes. There was a dog at the residence, and so the officer's quick thinking was, "Hey, why don't you come out into the hallway so the dog doesn't get out?" And she stepped out into the hallway. And when she stepped out into the hallway, you're going to hear that she did talk to the police. That she was very upset, that she was afraid, that she was whispering, even though they had taken several steps away from the apartment. She was whispering about what happened. She confirmed with them that she needed assistance. And you're going to hear that she talked about what happened. And she said to them exactly what I just told you. You're going to hear that she then wrote a full written statement saying the exact same thing. You're going to hear that later, after saying that she wanted to pursue charges, the next day she said that she changed her mind and she didn't want to pursue charges. You're going to hear that she never said it didn't happen, she just had changed her mind about pursuing charges. But at that point in time, the state became involved, and what was originally a private action by the two of them in their she was seeing blurs. And that at the point where he pressed on her neck and her chest, there aren't any physical injuries as a result of that. You can't see any bruising, but she felt it, and she couldn't breathe. You're going to hear that the officers that were involved had a dash cam, and that dash cam actually could capture what she was saying and what she told them on audio. You're going to hear that she told the defendant that she didn't call the police, which was true. She texted them. And you're going to hear that she told the defendant that they called and they said, do you need any help? And that's why she said no. Why? Because she was afraid of the defendant. On January 1st of this year, Faith Conference New Year's did not start off in a good way. The defendant caused or attempted to cause physical harm to her. We know that from him saying that he was going to abuse her like her ex did. That in terms of the definition of strangulation, he did the same. He put the pressure up her neck, her throat area, and she could not breathe. Based on the evidence that you'll hear from the officers talking to you about her demeanor and what she told them, and Faith Confer will testify as well, you'll hear that she did write a statement, that she confirmed that all of those things did happen, and at the close of the case, based on all the testimony, we would ask that you find the defendant guilty as charged. Thank you.
Thank you. Mr. Kuklinski?
Good morning. Members of the jury, in this case, the evidence will show that on January 1st of 2025, Mark Jackson committed no crime. In this trial, the state will tell you that Mark Jackson committed strangulation and domestic violence against Ms. Faith Confer. And that's the state's job, to convince you of that beyond a reasonable doubt. But members of the jury, in this trial, you also have a job. And that job is to consider what's presented to you and to find the truth. You find out and you decide what happened, what didn't happen, what's supported, and what's not supported. And today's case is going to be a messy case filled with inconsistencies. And the defense isn't going to pretend we can tell you precisely what happened on January 1st. But most importantly, the state's evidence won't show you what happened on January 1st, because the state doesn't know the truth. And the evidence will show that the narrative the state presents in this trial is not the truth. Mark Jackson was no menace to Faith Confer on January 1st, 2025. So let's go into a few things you'll hear about January 1st. You'll hear from Faith Confer that on that day she and Mark began arguing in their apartment in the wee hours of the morning over a Facebook message. A Facebook message Mark Jackson had received from another woman. And when questioned by police, Faith told them that Mark Jackson got on top of her, held her down on the bed, and obstructed her breathing for nearly 20 minutes. But there's some context to January 1st. At the time, Faith and Mark are mentally, emotionally, and physically spent. They're parents with a weeks-old newborn. They're cramped in a tiny apartment in an Ohio winter. Faith's frustrated with Mark, and vice versa, and they're arguing over that message Mark had received. You'll hear in this trial about the past trauma Faith has experienced, trauma from before she knew Mark Jackson. And you will hear a little bit today about how her trauma informed her perception of the events of January 1st. And you'll see how at first, on January 1st, nothing could calm Faith down. She contacted police, she made an accusation against Mark. And you will hear how at the encouragement of police, Faith wrote a statement. But the evidence will show, and Faith herself will tell you, this accusation was not accurate. In this trial, you will see how Faith Confer's initial account is not a consistent narrative. It's a narrative Faith herself will reject, and it's a narrative the state will tell you, the jury, to accept. In this trial, you'll hear from several officers, Officers Belusky, Federico, and others, and you'll hear that the officers found no concrete evidence to support the accusation Faith had made. In this trial, when you consider if the state meets its burden of proof beyond a reasonable doubt, consider what the state tells you to believe versus what the state will actually show you. What sort of evidence can you expect in this trial? Well, you won't see any evidence of injuries to Ms. Confer from this supposed brutal attack. Not even in photographs police took immediately after the incident. There's no bruises, cuts, scars, not even a scratch. You won't hear that any medical treatment was needed. You won't hear that there was hospitalization. You won't even hear that there was a doctor's appointment. You won't hear independent accounts from witnesses, nothing about yelling or screaming in that apartment at night, nothing from a neighbor, nothing from anybody who saw what happened on January 1st. And you won't hear any confessions or admissions from Mark Jackson. Mark Jackson, from January 1st, from day one, maintained his innocence. In this trial, you're going to wait for the state to show you more evidence beyond that initial accusation. And you're gonna wait, and you're gonna wait, and you're gonna be waiting until this trial is over. Members of the jury, finding the truth and determining the facts is your job. Proving the charges to you beyond a reasonable doubt, the highest burden in our judicial system, that's the state's job. Make the state do its job in this trial. Consider what you're actually shown, and one conclusion will be clear. At the end of this trial, my co-counsel, Ms. Rachel Smith, will come before you again, and she'll ask you to come to the only just conclusion in this case and find Mark Jackson not guilty. Thank you.
All right, thank you. All right, ladies and gentlemen, I'm going to let you go to lunch at this time. Remember what I told you a little bit earlier, don't discuss the case among yourselves or with anybody else. Don't look for any information from any other source, and do not come to any conclusion until the case is finally submitted to you. So we'll start back again at 12:30 with the evidence.
All right, so jurors, you can leave your notebooks on the chair's admission. They come back here and there's the situation more instructions, but you leave your notebooks with this.
Okay, have a seat. I finally found the original stipulation.
Okay.
So the felonious assault entry and domestic violence is Exhibit 1, Court's Exhibit 1. You want this Court's Exhibit 2 stipulation?
Yes, Your Honor. Sounds good.
Anything else to put on the record before we break?
No, Your Honor.
Not on behalf of Mr. Jackson.
Okay, see you at 12:30.
Yeah, long lunch.
Yeah.
leaving the court now, so I'll see you over there. I'm gonna bring mine. Exhibits.
Officer Joseph Federico, Federico.
Where are you employed?
Painesville City Police Department,
And what position do you hold there?
patrol officer.
How long have you been a patrol officer?
For Painesville, about 3 years.
Okay, and do you have other prior law enforcement experience?
I do.
Where?
Fairport Harbor, Perry Village, and North Coast Behavioral, and Madison Township.
And how long were you at Madison Township?
A year and a half,
And you said North Coast Behavioral?
about a year. There.
And what did you do there?
A police officer, but just patrolled the mental health units there.
Okay, and then you said Fairport?
Yes,
How long were you there?
about a year and a half.
Okay, and there was one more.
Perry Village, about 2 years, year and a half, 2 years.
Okay, so are you a certified peace officer in the state of Ohio?
I am.
How long have you been certified?
Coming up on 8 years now.
Tell me a little bit about your education, your training, your background that qualified you to be a peace officer in the state of Ohio.
The police academy at Lakeland, the basic police academy. I went there.
How many hours is that?
Roughly 650 hours of training.
And what types of classes do you have to take while you're there?
Law, accident classes, just your basic
With
curriculum.
each of those agencies that you were with, Jackson Township, North Coast, Fairport, that kind of thing, did you have to do specific training with the officers in that department as well?
Yes, they sent us to trainings.
And what about training with another officer? Did you train with another officer while you were at each of these departments as well?
When we went to trainings, whoever was on your shift would go to the training that they offered.
Through the course of your work then with being a peace officer in the state of Ohio, did you have occasion to respond to any domestic violence calls during the course of your work?
Yes.
Okay, what about calls involving strangulation?
Very, very few, but yes.
Approximately how many domestic violence calls have you encountered in your career?
Well over 50, I'd say.
And in each of those calls that you've been to, was there always an injury?
Not always.
Were there times when you went and someone had admitted to there being some sort of behavior and you still didn't see an injury?
Yes.
In terms of the cases that you have been involved with domestic violence, was there always an external injury?
Always? No. It's not always external.
Back on New Year's Day, January 1st of this year, were you working with the Painesville Police Department?
I was.
What shift and hours would you have been working?
The midnight shift, 7 p.m. to 7 a.m.
Busy day?
Yes.
During the course of your work on that day, did you end up going to Hollydale Apartments?
I did.
Were you in uniform and in a marked patrol car on that day?
I was.
When you say you're in uniform, were you dressed as you are today?
No.
Okay, how were you dressed?
I had our bulletproof vest on, different style pants and different style shirt with my badge and still patches on the sleeves.
And when I look at your uniform, was there anything, so you said you had a vest, was there anything else that you had that would have been on your uniform?
Besides my name, badge, patches on my shoulders, on my duty belt.
Okay, what's on your duty belt?
My pistol, magazines, taser, radio.
Okay. What about body cam?
We don't wear a body cam. We have an audio pack that's attached to the in-car camera that we have in our patrol cruisers.
Okay, so Painesville Police Department does not have body cameras?
Correct.
You said in-car cameras, so dash cam?
Yes.
Okay, how does that operate?
As soon as you turn the lights on, it'll automatically operate, or you can activate it by, on the audio pack as a switch, you just pull down on the switch and it'll activate the camera.
And when you activate that camera, what's the purpose of keeping it running?
To capture audio.
Okay, so even if your car is stationary, you can still capture something?
Yes.
Okay, what can you capture even if you're stationary or you're parked somewhere?
Anything we're saying, anything the people we're talking to are saying.
does that record in any way?
It does.
How?
It records to our WatchGuard system. When we hit stop, it saves, and then when we get to our station, it automatically downloads from our car to a storage database that we have at the station.
And did that happen on January 1st of 2025 when you went to Hollydale Apartments? Was there a dash cam?
There was.
And did you have an opportunity to review that dash cam video?
I did.
What does it show picture-wise?
My vehicle parked behind Unit 722.
And do we see anything other than that really from that vantage point?
No.
What about audio? What can you hear?
You can hear myself, Officer Blowski, speaking with the victim, Faith. You hear us talking to other officers on the call.
And who are the other officers on the call?
Officer Blowski, Officer Grove, Officer Witt, and Officer Flanagan.
Can you hear those voices then on that dash cam?
Yes.
Why did you respond to Hollydale Apartments on New Year's Day?
Our dispatch got a 911 text, and when they called the number that texted it back, they asked if they were okay, and they stated, whoever's on the other end stated no, and they hung up.
Okay. Is that unusual for you to get something with a 911 text?
I'd say it's not common.
And so did you then, once you got that information, did you respond to Hollydale?
I did.
How long after you got the call did you respond?
We were dispatched, probably took us 3 minutes to get there, 5 minutes to get there.
And where specifically did you go?
To Building 4, Apartment 107.
Whose apartment was that?
Faith Confers.
And was there anybody else that you learned was residing there with her?
Yes, her boyfriend, Mark Jackson.
And Mark Jackson, did you see him initially when you got there?
Not initially, no.
Okay. Explain for me, when you arrived, what you observed.
So we knocked on the door. Faith had answered the door. Myself and Officer Blowski were kind of asking her if everything was okay. So she said she was just going through things, and as we were talking to her, she kept looking behind, the door was to her left as she opened up the door, and she kept looking nodding or looking behind the door, insinuating someone might have been there. Just something felt off to where I asked if she can step out and talk to us, just so the dog doesn't come out. So that's what she did. And
So when you get there, does she open the door all the way?
not completely all the way. She kind of opened it about normal halfway to where we can see her body.
I'm sorry?
To where we can see her body.
Okay. Was there anything that you noted about her when you saw her?
She just looked, she looked a little upset. She said she was going through things, and just the way she was looking behind the door.
Okay. And could you describe the way that she was looking behind the door that made you think there was someone there?
She kind of just moved her eyes, pointing to the left side, which would have been behind the door, insinuating someone might have been behind the door.
Okay. Did she just do that once?
I can recall once. I don't know how many times she would have done it.
And that led you to believe there was somebody behind the door?
Yeah.
You said something about a dog. Was there a dog in the apartment?
There was.
Okay. And so what did you tell Faith at that point in time?
I was like, can you step out and talk to her just so the dog doesn't get out?
And did she do that?
She did.
And what happened when she came out into the hallway?
We went up the stairs to where the entrance to the building was and chatted with her.
Why did you go away from the apartment?
Just because I wanted her, because she wasn't being, when we were talking to her at the door, she wasn't bearing, it seemed like she was being kind of reluctant to really talk to us. So maybe because of possibly someone behind the door, so that's why we went upstairs or to the top part of the landing, so we can talk a little bit more, make her a little bit more comfortable to talk to us.
And what was her demeanor while she was talking to you?
When she was talking, her throat was scratchy. when she was talking to us and the other officers, at some point she would like cry or get choked up, explaining what took place inside the apartment.
And about how long did you speak with her while you were there on scene?
Me personally, probably a total of 5-10 minutes,
And how long were you on scene?
about an hour.
Did you talk to her for a straight 10 minutes, or was it off and on?
Off and on.
And when she said that she was going through stuff, did she explain to you what had happened?
She explained to us what took place inside the apartment.
Okay, and how long before you guys arrived had that occurred?
I can't say. I don't know.
So you said the 911 text came in, and how long did it take for you to get there?
Probably around 3 minutes, 3 to 5 minutes.
Okay, and so when you got there, it's only been like 3 to 5 minutes after the 911 text.
Yes,
Okay. And does she seem upset?
she does.
What do you mean by somebody seeming upset?
She's speaking up with like a really low tone of voice. She's kind of reluctant to talk with us and provide information to us when she was in the door. When she explained what happened, she would kind of get choked up, explaining in detail what happened.
Now, as you're talking to her, she's reluctant, you said she's reluctant at the door. How is she once you get her out of the apartment and on the landing to talk to her?
She opened up and explained in detail what happened inside.
Okay, what did she tell you happened?
She got in an argument with her boyfriend over a message she saw on, I think it was his phone. She went inside the bedroom, he followed her, pushed her on the bed, and put his arms on her chest and like laid on top of her. And she's saying she was choked for about 15 minutes and she couldn't breathe. And she started to see like blurry spots.
When she's talking to you about this, did she just tell you that one time?
No, that was her statement throughout the time we were there.
Did she talk to multiple officers while she was there?
She did.
Did you hear her speak to other officers?
In passing.
And was she consistent with what she told you?
Yes.
When she talked about him being on top of her, can you explain what specifically she showed you?
She was, I can't remember the emotion she did. She just said,
Objection. Sustained.
And did you ask her about her voice?
yes,
Okay. And did she explain to you why her voice was the way it was?
yes,
How would you describe her voice?
scratchy.
And what did you ask her about that?
I asked if her voice was normally like that. She said no.
Okay. And did you understand why, or did she explain why her voice was like that?
She said it was because she was choked.
Objection. Sustained.
During the course of the time that you're talking to her, what are her emotions?
Sad. It's not, she seemed upset, sad and upset.
Did she tell you how long before this incident had happened?
Not that I can recall.
Now, in looking at the doorway to the apartment, were you able to actually observe that? The door of her apartment? Did you go to the door of her apartment?
Yes, we did.
Okay. And can you describe what you saw in that door?
A wreath, and people through the little knockers.
Okay. And when did Faith end up talking to you? Was the door open or closed?
The door was open.
And then when you went up on the landing, was the door open or closed?
It was closed.
State's Exhibit 1A through 1I. May I approach, Your Honor?
Yeah.
All right, Officer Federico, I'm gonna hand you some rough identification here in State's Exhibit 1A through 1I. I'm gonna ask you to look through those first, and when you're finished, let me know.
I'm done.
Do you recognize what those are?
I do.
Okay, what are those?
Photos of building 4 at Hollydale and then leading up to Faye's apartment door.
Okay, and do those fairly and accurately depict that area?
It does.
Okay, you start with Exhibit 1A, if you could describe what that is.
A picture of the outside of the building.
Okay, and what about 1B?
Of the walkway leading up to the entrance of the building.
And when you say the building, what building?
Building 4.
Okay, what about C?
The actual door you walk through to get into the apartment building.
Okay, and 1E?
The door with the unit number on it and the people.
And 1E?
Just a closer up picture of the door.
Okay, and then 1F?
A different angle of the partially of the door and then the downstairs landing area.
Okay, and 1G?
The stairway where we walked up to talk with Faith.
Okay, 1H?
The same area.
Okay, and 1I?
The same area but just a different angle.
Okay, I'm gonna ask you to, when you look at those photos, if you could pick out the photo that shows where you spoke to Faith. We have two photos. So what's the first photo?
First one is where we first initially spoke with her, and then the second picture is where we walked to after she agreed to come out. And
Okay, how far away is that second photo away from the door?
20 feet.
And when we look at, we have State's Exhibit 1D and 1H. When you look at 1H, can you draw an X on that photo where you spoke to her? And did you maintain your contact with her on that landing the entire time?
Yes.
And did she go anyplace else other than that landing?
No, and I believe when she filled out a statement, she sat on the stairs going up at one point.
So she wrote out a statement in this case?
She did.
And was that statement consistent with what she told you?
Yes.
Was it consistent with what she told other officers?
Yes.
At any point in time while you were there, did that series of events or the facts about what happened that day, did that change?
No.
Was there anyone else, did you learn if there was anyone else besides Faith and the defendant in that apartment?
Their child.
And how old was the child?
I can't recall. Yeah, seeing him, he looked like a newborn infant.
Now, as you're talking to Faith, did you observe any visible injuries on her?
No.
Did she explain to you what part of her body this happened to?
her chest, upper chest area.
And then did you end up taking photographs of that and her?
I did.
Your Honor, for the record, I'm showing opposing counsel what I've marked as State's Exhibit 2A, 2B, and 2C. May I approach, Your Honor? I'll show you then what's been marked for identification, State's Exhibit 2A, 2B, and 2C. If you could take a look at those, tell me if you recognize what those are.
I recognize them.
Okay, and how do you recognize those?
They're photos I took.
And who is in State's Exhibit 3, or sorry, 2A? Who is that?
Faith Gomper.
And why did you take that photo of her?
To show the areas of where she was, where the injury or the choking took place. So she said.
And she specifically described choking.
Yes.
Okay, so when you look at State's Exhibit 2B and 2C, why did you take those photos, and what are they of?
The front of her neck.
And that's 2B and 2C?
Yes.
Okay, and do those three photos, do they fairly and accurately show what she looked like that day?
Yes.
When looking at her, did you observe any outward external physical injuries?
No.
Okay. Was there anything that you noted about her that signified any kind of injury to you?
Her voice sounded scratchy as she spoke with us.
Now, in terms of looking at the photo of her in State's Exhibit 2A, how long after this incident was that photo taken?
This was towards the end before we left.
Okay. And is there anything that you noted about, or you can note about her eyes still at that point in time?
They look a little swollen, puffy.
When you went and took those photos, did you take more photos than, other than just photos of her?
I did.
And what other photos did you take on that day?
Of the inside of the apartment and where she said the incident took place at.
Okay, so she had told you, she had explained to you what had happened inside the apartment, so you took those photos?
Yes,
Did she allow you in the apartment?
she did.
Did she take you in and show you where these things had occurred?
She said it happened in her bedroom.
Your Honor, for the record, I'm showing opposing counsel what I've marked for identification, State's Exhibit 3A through 3K. So for the record, I'm going to show you what's been marked as State's Exhibit 3A through 3K. I'm going to ask you just to look through those first and let me know when you're finished.
No.
Do you recognize those photos?
Yes,
How do you recognize those?
I took them.
And if you could walk through and explain for us what each of the photos is and why you took that photograph.
This first one is just a picture of her door. That's where we spoke with her at. The second photo is a closer up picture showing the apartment number. The third picture is showing what you see when you open up the door and when nobody's standing in the way.
So when you look at that photo, what number is that one?
3C.
Okay. When you say when nobody's standing in the way, so that would be, is there a clear view in if nobody's in the way?
Yes.
When Faith Confer opened the door, is that how the door appeared to you?
No.
What was different?
You could really just only see her standing in the doorway.
All right, now going to the next photo, what's the next photo?
A photo of the bedroom.
And why did you take a photo of the bedroom?
'Cause that's where she stated it happened. The incident took place, sorry.
All right, and what about the next photo? What's the number on that?
Next photo is 3E, I believe.
Okay. What is that of?
It's another photo of the bedroom.
And why did you take that photo?
Just shows when you're standing at her doorway looking straight in, just what you see.
And what about 3F through 3K? What are we seeing in each of those photos?
This is photos of the bed where she said she was pushed onto.
And so well, start with 3F. What's in 3F?
Pillows, lamp, like smaller blankets. It's like some diapers.
So there are items on the bed?
Yes.
Okay, and you took a photograph of the bed from that angle, why?
It's because where she said she was pushed onto.
Okay. What kind of bed was it? What size? King, queen, full, twin?
Looks, from the pictures, kind of looks like a full, possibly a queen, but
And did it have, that bed, did it have items on it?
it did,
In addition to those pillows?
yes.
Okay, what about 3G?
The other side of the lamp, it's like a diaper bag with diapers in it.
What about 3H?
It's another angle of the same items on the bed.
Okay, why did you take so many photos of the bed and the different angles on the bed?
Just to show the area that it happened in different angles.
Did you take photos of a bunch of other rooms in that apartment?
No,
Why not?
because it didn't have, I just wanted to take pictures of where she said the incident took place at. And it wasn't necessary to take pictures of any other room.
So in looking at State's Exhibit 3A through 3K, do all of those fairly and accurately depict the photographs that you took going to apartment 107 on January 1st of 2025?
Yes.
And while you're in the apartment, are you just kind of moseying around by yourself or someone with you?
No, I had Officer Witt was with me as well.
Where was Faith during these photographs being taken?
I can't recall if she was in the kitchen or with us.
And how did you know where to go in the apartment and what to photograph?
I believe she said of where her bedroom was located at.
So this is Faith telling you where these things happened?
Yes.
So you didn't have to guess or anything like that?
No.
Now, you said that you had dash cam on that day. Is that a fair statement?
Yes.
Okay, did the other officers that were involved, did they also have dash cam?
I believe everybody's dash cam was activated.
Do you have an opportunity to listen to the other officers' dash cam?
Not theirs, but mine. I listened to them.
And in listening to yours, were you able to hear what transpired on that day?
Yes.
And how easy was it for you to hear that?
Wasn't the clearest, but you can hear what was being said.
When you activate, or when your dash cam is activated, does it record clearly the entire time?
No, there's some static. Sometimes there's in-car radio that you can hear, but for the most part, you can hear what's being said.
And when you farther away from the car, does that, your ability to hear it change a little bit?
It does.
And how does it change?
There's just constant ticking sound that you hear, and it gets louder as I get farther away from the car.
And you had an opportunity to then listen to your dash cam?
Yes.
Okay. And I'm just showing opposing counsel, it's been marked as State's Exhibit 10. May I approach? Or do you recognize State's Exhibit 10?
Yes.
How do you recognize State's Exhibit 10?
It's a dash cam that we listened to and that I signed.
Okay. So you were able to listen to your dash cam. Did that fairly and accurately depict what transpired on that day?
Yes.
And whose voices can you hear on your dash cam?
Mine, Officer Witt's, Faith's, and Officer Groves that I can recall.
And then I'm going to show you, I'm just showing opposing counsel, it's marked as State's Exhibit 7. Show you what's been marked as State's Exhibit 7. Do you recognize what that is?
A flash drive.
Okay, and do you recall looking at that flash drive and listening to the flash drive?
If it's the snippets of the audio, yes.
So you listened to portions of your dash cam snippets of that?
Yes.
Okay. And when you listened to those from State's Exhibit 7, did they fairly and accurately depict what's on State's Exhibit 10?
Yes.
Have they been altered in any way except for the fact that they're shortened?
No.
Throughout listening to the dash cam, are you able to hear everything that Faith is saying?
Yes.
How would you describe her tone if she's talking to you throughout that day?
Low,
What do you mean by low?
as if trying to be like discreet, not talking like normally how I'm talking now.
Okay, so is it easy to hear her and everything that she says throughout the dash cam?
No.
But you were there present with her and you had an opportunity to speak with her,
Yes.
and you know what she said.
Yes.
Are you able to hear on the dash cam her change in her demeanor and the way that she's talking?
Yes.
What are the distinctions that you're able to hear?
At the doorway, it's very quiet. It's harder to hear her. But as we talk to her on the landing, she's still quiet, but she's explaining everything that happens. And then towards the end of the encounter, she's talking normally now and as if it's just a little bit more comfortable.
Okay. And how much time has passed?
Between the start of the call and the end, for like an hour.
And in taking the photographs of her neck, even though you didn't observe any physical injuries to her neck, what was the purpose of taking those photos of her neck?
Just to show where she explained she was choked out.
And he said she explained where she was choked.
Yes.
And in terms of her being choked, what did she say happened?
Objection. Sustained.
Can I maybe approach?
Yep. For the present, that objection sustained. Go ahead, Ms. Linden.
When you spoke to Faith, what was the date that these things happened? Was it that same day, that January 1st?
Yes.
And the call came in around what time, do you remember?
1:53 in the morning.
1:53 in the morning, and you said that was the 911 text.
Yes.
And then you responded and you got there how long after?
3 to 5 minutes.
What did you say?
3 to 5 minutes.
So that 3 to 5 minutes to arrive there, and when you got there and Faith was at the door, how long did it take you to get up to the door?
45 seconds maybe.
And as you're up at the door and you knock on the door and she opens it, how far does she open it?
Enough to see her body.
And you said she was doing something with her eyes. What was she doing with her eyes?
Looking to the left, to which would have been the way the door was opening.
Okay, and her demeanor at that point in time?
Kind of reluctant to speak with us, saying that we were asking her if everything was all right. She said she was going through things.
And didn't really go into any more
Didn't go
detail?
into detail, no.
When she says she's going through things and you see her kind of nodding off to the fact that there's somebody behind the door, what did you have her do?
I had her step out to talk with us.
Okay, and when you're talking to her and you're asking her about what happened and she's talking to you about what happened, how would you describe her demeanor throughout talking to you?
Just sad, because she was speaking with like that low tone of voice, maybe even scared. Someone to describe it.
So still scared.
Yeah.
And when she's describing what happened, is this a description of something that happened, days or weeks or months ago?
No.
When did you understand that this incident had happened?
That night.
And how close in time prior to your arrival?
It's hard to say, but if I had to guess, not too far off.
When you talked to her, did she give you a time frame about how long she'd been on the bed?
15 minutes.
So at least 15 minutes prior to this, maybe a little longer?
Yes.
Okay. And when you're asking her about what happened, did she continue to be upset while she was talking to you about the incidents that happened?
Yes.
Okay. Was she asking anybody any questions?
I don't know what you mean by that.
Was she talking to anybody else, asking anybody questions, or was it just her there?
It was just her there talking to us.
And was she relaying to you what had just happened?
Yes.
What did she relay to you?
That she got in an argument with her boyfriend over a phone or a message she saw on his phone.
There was an argument about the phone.
Mm-hmm.
And then what?
She went to the bedroom. He followed her to the bedroom. He pushed her on the bed and got on top of her and began putting his weight onto her to the point where she couldn't breathe.
And when she's talking about that, she's describing that to you. Is that why you then ended up taking those photos of that bedroom?
Yes.
And did she describe anything else to you about what he did or what he said?
Said, I'm going to treat you like your ex did and abuse you.
And did you understand what that meant?
Not until I re-listened to the audio, and she explained that her ex had
Objection. Overruled.
her ex had treated her poorly. I don't know if you want me to go into detail.
What do you mean by poorly?
Abused her, choked her, raped her.
And so she's then telling you that the defendant here is saying that he's going to treat her the same way.
Correct.
And when she's telling you that part of it, she's talking about her ex. What was her demeanor like?
She started to choke up, get more upset.
And did she say then why it was that she called 911 or texted 911?
I can't recall exactly why, but she just said she texted 911.
And how long did she say that he was on top of her and that he was choking her?
15 minutes.
And where was the child when all of this was happening?
Next to them in the bed.
In that bed that you took the photo of?
Yes. Said she tried to roll, but she couldn't because the kid was there.
And so what did she do?
Spoke to him in like a calm voice, and then it stopped.
What stopped?
The choking.
And what did she do then?
She got up and I believe she went out of the room.
And the person that she said did this to her, did she talk to you about who it was?
She said it was her boyfriend.
Did you meet her boyfriend?
We saw him that night, yes.
And do you see that person in the courtroom today?
It's been a while, but I believe it's the gentleman at the defense counsel table.
What is he wearing? And describe what he looks like?
I believe a sweatshirt. As a black male, was wearing a white sweatshirt.
May the record reflect the identification.
Yes.
Was there anyone else in that apartment that she said did this?
No.
Anyone else around?
No,
Did you speak to anybody in any of the apartments, Fletcher?
I did not.
Why not?
I just did it that night.
Was there anybody out milling about, talking, anything like that?
No.
Okay, again, what time is this?
1:53 in the morning.
1:53 in the morning, okay. And so, and this is New Year's Day?
Yes.
Okay, so nobody's like running to come and talk to you guys at that point in time?
No.
All right, what did you do then after you spoke to her and you took those photographs?
After I went back outside, and then we left after the photographs were taken.
Okay, all right. And did you obtain any kind of written statement from Faith Comfort?
I personally did not.
Okay. Did somebody else obtain one for you?
Yes.
And that was another officer?
Yes.
Your Honor, may I have a moment? All right, Officer Federico, in looking at State's Exhibit 7 that you had an opportunity to listen to, what you've explained to us about Faith, is that recorded on this?
Yes.
Mayor, at this point in time, I'd ask to publish this for the jury.
That's,
No objection.
all right. Go ahead.
When listening to this, whose voices are we going to hear on here?
Mine and Faith's.
Okay, are there any other officers' voices that we'll hear?
Officer White, I believe.
Sir, I heard you all the what did you say? He was mentioning my accident, and my accident, all we can feel for my rate control me. He took on 3 ounces of rape on me.
Now listening to that, we hear that clicking sound. Is that what you're referring to when you're kind of far away from the dash?
Yes.
Yeah? Okay. And when we're listening to that, whose voice do we hear?
Mine and Faith's.
Okay, and how do you describe Faith's voice when you hear it there?
Kind of like shaky.
And what, did it sound the same initially when you talked to her as it does on that audio?
Yes.
Kind of hard to hear a little bit, just because of all the clicking. But is she saying what you've just relayed to us here in court?
Yes.
Now, did you tell her to say that?
No.
How is it that you got that information from her?
I asked her what happened.
And this is her telling you what happened?
Yes.
Did you pressure her in any way to write a statement or talk to you?
No.
Because of fucking, the murder. Is your voice lower or anything like that? No. Why? When did it feel like that? After he choked me. Oh.
Okay. And you asked for what there?
If her voice normally sounds like this.
And what is her response?
No, because he choked me.
We got into an argument and he started like choking me out on the bed. Please let me go, I can't breathe. My boyfriend. Yeah.
Whose voices do we hear there?
Faith and Officer Woods.
Okay. And there's a dog there?
Yes.
Okay, was that her dog?
Yes.
So when did Officer Witt show up in person when you were there?
Probably like 10 minutes, roughly, after we got there.
And when she's saying, oh, hey, who she's talking to?
I believe Officer Wood.
And then she explained what happened?
Yes.
No, not a ton of detail, but just basically?
Yes.
Was that consistent with what she told you?
Yes.
So the first clip, Your Honor, is listed on State's Exhibit 7 as video 1, the second one was video 2, third one was video 3, and this is going to be video 4A through B. We'll go with 4A first.
15 minutes, I couldn't breathe, I was so I was after that.
What's it all over?
Text messages on his Facebook.
Same thing that she told you?
Hmm?
This
Yes.
argument is over Facebook?
And messages on Facebook, yes.
And 4B.
Because he started choking me, I'm like, I can't breathe.
Okay, so she specifically talked about not being able to breathe?
Yes.
And then when he came in there, I was like, please leave me alone. I texted him. I was like, please leave me alone. I don't want to talk anymore. He was like, no, I'm not going to leave you alone. I'm going to treat you like your ex did. So you can say that I abused you.
And the prior one, 4B, how long did she say that this happened for?
That choking about 15 minutes.
Okay, and this particular video, whose voices do we hear?
Faith.
Okay, and is this, again, what she told you?
Yes.
Tell me again why he held you down. He told me he was going to make me feel like my ex did. Is there a particular reason why he said that? I told him that he was holding me down. He was acting like my ex, because that's what my ex did when he raped me, and it was triggering my PTSD. But why did he hold you down? Because he was mad. Mad. Because I wanted to see his phone. I was showing him something that I sent him, and then I was getting on a message on his phone. Okay.
So what was your understanding of why this whole argument started, why he held her on the bed and choked her?
Over messages on his phone?
On Facebook?
Yes.
Nothing further at this time, Your Honor.
Cross?
Your Honor, prior to proceeding, may I approach just recover state's exhibits 2A?
Yeah, go ahead.
2C. Thank you. As well as
Okay.
afternoon, officer.
Good afternoon.
Now, officer, when you met with Ms. Confer on January 1st, as you mentioned on direct, you observed no injuries, correct?
Correct.
When an alleged victim makes an allegation of domestic violence or strangulation, you'd agree it's proper police practice to look for injuries, correct?
Correct.
And you'd agree it's proper police practice to look thoroughly for injuries, correct?
Correct.
And that's what you did in this case, you looked thoroughly for injuries.
Correct.
And you looked multiple times for injuries as well, correct?
I looked at her neck.
You did look at her neck?
Yes.
Okay. And the allegation, as you understood it at the time of this, was that she was alleging he held her down 15 to 20 minutes or so?
Yes.
And officer, would you agree somebody who's been strangled for 15 to 20 minutes presumably would be more likely to show injury than someone who's been strangled for 1 minute or 2 minutes?
It's hard to say. I haven't handled many strangulation cases. I can see how some might be different than the others.
But presumably 15 to 20 minutes you would agree would be different than 1 to 2 minutes.
In a sense, yes.
And again, since there was this allegation of strangulation, you again focused on Ms. Confer's neck during your investigation, correct?
Correct.
And there were no cuts or bruises.
Not that I saw.
You didn't observe bloodshot eyes either, correct?
Not that I can recall.
And presumably that could be an indicator of strangulation.
Yes.
And Officer Federico, there were several other officers who were there with you that day, correct?
Yes.
Based on your knowledge, none of them observed any injuries on Ms. Confer's person, correct?
Correct.
And I know on direct, you viewed several pictures you had taken on January 1st, is that correct?
Yes.
Your Honor, may I approach the witness with what's been marked for identification as States Exhibits 2A, 2B, 2C? And officer, just as a brief refresher for the jury, what do those pictures depict?
One full photo of Faith, and then a photo of the front of her neck and the side of her neck.
And again, I take it, viewing these pictures today, again, no observation of injuries, correct?
Correct.
Officer, I'd ask you to take a glance at Miss Confer's shirt in that picture. And just look up at me when you've had a chance to observe it. Okay, and on January 1st, officer, you didn't observe that that shirt was stretched out?
Not that I can recall offhand, but
But you didn't observe it was torn, anything like that?
No.
And you certainly would have documented it had you observed that, correct?
yes.
And Officer Federico, I know on direct you mentioned as well, you've taken multiple pictures of the scene.
Yes.
In particular, I know you spend a lot of time discussing the bed on the scene, correct?
Correct.
Your Honor, may I approach the witness with States Exhibits 3I and 3B?
Yeah, you can approach anytime you need to.
Thank you, Judge. And officer, just as a refresher, what do these images depict?
The bed.
And officer, in those pictures, the blankets and pillows are still on the bed, correct?
Correct.
And as you mentioned on direct, you arrived on scene maybe 3 to 5 minutes after the alleged incident occurred?
Yes.
Okay. Now, officer, on direct, you also spoke about Ms. Confer having a kind of scratchy voice.
Yes.
Would it be fair to say you'd never spoken to Ms. Confer before that day?
I believe I had one other encounter with her.
Was it recent in time to this encounter?
Not super recent, no.
Okay. And officer, you agree that somebody's voice might sound scratchy for a number of different reasons, right?
Yes.
Could be someone has a sore throat.
Yes.
Could be someone's a smoker
Yes,
and would just be shouting.
yes,
It could be because someone's emotional or upset.
yes,
You would agree that was something you and the other officers considered, right? The fact that Ms. Comfort was upset.
yes.
And you considered that could be a factor in the scratchy voice, correct?
It could be, yes.
Officer, it would be fair to say on January 1st, EMTs were never called to Ms. Comfort's apartment.
Correct.
You would agree it wasn't necessary in this situation.
I believe she was asked. If I recall correctly, she was asked, and I don't think
So
it was requested.
asked, whether or not she wanted EMTs to come.
I believe so.
Okay, and your understanding was she declined.
I believe so, yes.
Had she requested EMTs, you would have called EMTs?
Yes.
Had she had visible injuries or seemed to be in medical danger, would you have called EMTs?
If she was in medical danger, yes.
Okay. And to your knowledge, she never ended up going to the hospital?
Correct. Correct.
To your knowledge, she didn't end up going to the doctor after this?
Not to my knowledge.
Okay. If Ms. Comfort had bruises on your neck, would you have been more likely to encourage her to go and get treatment?
I would ask her if she would like to go to the hospital, but we can't force anybody to go to the hospital.
Okay, so you wouldn't have encouraged it?
I would have asked if she would like to go, yes. Or if she would like to be seen by our fire department.
Okay, in this case, you didn't ask whether she'd like to be seen by the fire department, though?
I didn't know.
Officer, I want to jump back just a little bit to when you first arrived on scene. Now, when you arrived on scene, Ms. Confer and Mr. Jackson weren't engaged in any sort of fighting, right?
No.
You didn't hear any yelling as you approached?
No.
Ms. Confer was the one who answered the door?
Yes.
You didn't see anybody out in the hallway, any neighbors milling about?
No.
And would it be fair to say Ms. Confer was the only person you're aware of who contacted police regarding this incident?
Yes.
So no neighbors reported a disturbance?
Not to my knowledge, no.
No passersby reported a disturbance?
No.
Now, Officer Federico, I know we viewed a few snippets from your dash cam previously. I take it you recall reviewing those?
Yes.
Was your dash cam operative essentially from the start to the finish of reporting to the address on Hoyt Street?
Not on Hoyt Street.
Overruled. No, I'll repeat it. Was your dash cam operative essentially from the start to the finish of when you reported to scene on Hoyt Street?
The scene wasn't on Hoyt Street.
I'm sorry, could you clarify to the address, Ms. Confer's address?
908 North State Street, Building 4, Apartment 107.
Yes, so was your dash cam activated for the extent of your time reporting to the scene?
We activated it, I believe, as we're getting out of our cars, and it activates the camera at least 45 seconds before, so it'll show like 45 seconds before of us driving, and then it'll show us pulling in.
So would you agree the vast majority of reporting to this incident was recorded on dash?
Yes.
And how long in total would you say your dash cam recorded, if you recall?
Probably about an hour, maybe.
Okay. And those snippets we watched previously, that was, what did you say, that was approximately maybe 2 minutes of dash cam footage?
Yes.
And you would agree there's a great number of minutes, a great number of, close to an hour of dash cam footage this jury has not yet heard, correct?
Correct.
Okay. We have one moment, Your Honor.
Yep.
Thank you, officer. I have no further questions.
Any redirect examination?
Yes, Your Honor, thank you. Officer Federico, you listened to the whole dash cam. The snippets that we took, are those things that were just repeated over and over and over?
Yes.
So, you and other officers are talking outside.
Yes.
So this basically documents the entire call, and your conversations with other officers, walking back and forth to buildings.
Yes.
So here, it's not just a matter of that small little part of the dash cam being the only thing that was said. It's just, those are the parts that are easier to hear.
Correct.
And through that entire hour that you're there, does anything that she says change?
No.
And here, it was your understanding that 911 was called via text,
Correct.
not an actual phone call.
Yes.
When she's talking to you about, when Faith's talking to you about what happened, saying that she couldn't breathe, would you, in your training and experience, say if she's saying she couldn't breathe and she's being choked, would other people be able to hear what was happening?
No.
Is it unusual in your training and experience when you respond to domestics or assaults or anything like that for people to refuse medical treatment?
It's not unusual.
Are there even times when people are injured and they still refuse medical treatment?
Yes.
Like you said, can you force them to have medical treatment?
No.
Now, there are all kinds of reasons. You were asked about having a scratchy voice. Why did she tell you that her voice sounded like that?
She was choked.
And just to be clear, the other time that you spoke to Faith before had to do with a dog that they found that had fleas.
Correct.
And that was your contact with her.
Yes.
Do you really remember any of the details of speaking to her on that date?
No, just that they found a dog and I had her boyfriend actually carry the dog to my car.
And when she's describing what's happening, you were asked about like the bed and what's on the bed. When she's on the bed, is she on the bottom or the top of the two of them?
She's on the bottom.
And does she say that he's choking her for 15 to 20 minutes or that he held her down for 15 to 20 minutes?
You choking her for 15 minutes.
Okay. And this is all, when she's describing choking, does she describe hands around the throat?
No.
How does she describe the fact that she is being choked and can't breathe?
She said he used his forearms.
You're making like a,
Like
your
a,
arms up like
yeah,
with
just
across or next to each other?
kind of just next to each other, just pushing on her chest.
So he's on top of her, pushing down.
Yeah.
Okay. And the area that you took photos of was the neck and this area of the chest.
Yes.
Is that where she said that pressure was being placed?
Yes.
And we're not talking about punching or using your fingers where there might be additional marks, right?
Correct.
This is actually just the pressure itself
Yes.
from the forearms. And do you know whether or not the shirt that she was wearing in that photo, is that the one that she came to the door in?
Yes.
Okay. Do you know if that's the shirt she was wearing the entire evening?
I do not.
Did you think to ask her about that?
No.
Thank you. Nothing further, Your Honor.
Any recross?
Nothing based on that, Your Honor.
All right, you may step down. Thank you.
Thank you.
We're going to take about a 10-minute break. Remember not to discuss the case among yourselves with anybody else. Don't try to find out any information from any other source. And do not come to any conclusion until the case has been submitted to you. So we'll start at about 8 minutes to 2 o'clock.
All right.
not a whole lot of room
Yeah, there isn't.
here, so if I leave them
That's
here,
fine.
is that okay?
Yeah.
That way if you need them.
Thank you.
Since April of 2024.
And is Legend, is that your child?
Yeah.
Okay. And do you work?
I do.
Okay, where do you work?
Paolo and Willoughby,
What is that?
aerospace manufacturer.
What kind of hours do you work?
Full time, anywhere from 40 to 60 hours a week.
What's a general time frame that you're there?
6:30 to 2:30 is my normal hours, but based off what we have, sometimes I'm there later.
And where does Legend go while you work?
Legend is with Dad during the day.
Okay, so he's with Mark during the day?
Yep.
Do you have any other people available to be caretakers for him?
No.
So you rely on him?
Yes.
Does he work?
No. Currently, no.
And when did you start your job with Paolo?
I started January 5th as a temp and got hired in May 5th.
So on January 1st, were you working?
I was not.
Okay, what about Mark? Was he working?
No.
All right, so back on New Year's Day of this year, you recall talking to me about what happened on that day. Fair to say?
Yes.
And we spoke twice.
Yeah.
And we talked about your written statement,
Correct.
and we talked about your relationship still with Mark.
Yes.
And you are still with the defendant,
Correct.
right? Even after January 1st, you're with him.
Yep.
And is it fair to say that perhaps you didn't tell him exactly what you told the police?
That's fair.
And when he asked you if you called the police on that day, your answer was no. Fair to say?
Correct.
And when you and I talked about it, you said this because you texted. It wasn't a call. It was
Correct.
a text. So you texted 911.
Correct.
And the reason that you texted 911 is because you were afraid.
Angry and afraid, yep.
Now, and I don't mean to delve into this, but the person that you were seeing before Mark, his name was Tone, you called him Tone?
Correct.
Did you explain your relationship with Tone to the defendant?
Yes.
And explain what happened? And that was a pretty traumatic relation, I'm not gonna say relation, but that was a pretty traumatic experience for you.
Yeah.
What was it about Tone that was so bad?
He was abusive mentally, physically, emotionally, very unstable. He was terrible as a person, but it didn't start like that.
Started out, he was pretty nice.
Yeah.
And then all of a sudden,
Yep.
things changed. And when you were in a relationship with Tone, fair to say that there were times when he would hold you down or choke you?
He would choke me, yeah.
And with that happening with you, did you explain to the defendant how difficult that is with those kind of behaviors?
I explained to him what happened. As far as like specific behaviors, no. He knew what happened to me, but I didn't go through every action that Tone did and how it made me feel. He just knows the overall feeling of how I felt.
And I remember you saying to me that you had PTSD as a result of that. What did you mean when you told me that?
I have post-traumatic stress problems and symptoms because of that.
Because of what happened to Tone?
Yeah.
And were you clear with the defendant about things that were triggers for you?
He knew some, not all.
But the choking he knew.
Choking, yes.
And did he sometimes act a certain way where you would say that he was acting like your ex?
I'd compare him out of anger, yes.
And when you compare him out of anger, it was something that he did that was similar to what your ex did.
That and to make him angry at me.
Now, I'm not saying that the defendant did the types of things that Tom did here, and that's completely separate.
Not comparable at all.
Okay. And so, from your perspective, what happened with Tom was awful.
Despicable, yeah.
And so, something a little less than that, or, less than that, might not seem so bad.
Fair enough to say.
Okay. So on New Year's Day, is it early in the morning, late at night, that you text 911?
Late at night,
So had you already done the ball drop and all that?
yeah.
And how were things between the two of you then?
Up until that point or before that point, okay.
And there came a point in time where you two argued about something that came up on his phone.
Unsent Facebook message or a message that he had received.
And so there was a little bit of jealousy going on your part. You didn't know why he's getting this message.
Correct.
Did you confront him about it?
I did.
And what did he tell you?
He said he already shown it to me. I did not remember him showing me the message, so I got upset. He became defensive, so that pissed me off even more.
So this message, you wanted to see it, right?
Yeah,
And you took his phone.
I grabbed it from him, yep.
Took his phone, and then when you were talking to me about what happened that day, he was just kind of like in your face all day and wouldn't leave you alone. Is that fair to say?
Yeah, he was picking at me.
Okay, so he's picking at you all day, and you just were done with it. You wanted just to go in the other room.
Yeah.
And you told him to leave you alone.
Yes, I did.
And you went into your bedroom. And did you take the phone with you into the bedroom?
No.
Okay. When you go into the bedroom, did you sit down on the bed?
I did.
And when you sat down on the bed, did he leave you alone?
No.
So the defendant comes into that room. How long after you go in there?
I don't recall.
Was it like a long time later? Short time?
Probably not long, but it wasn't short. I was angry and irritated, so I don't really know.
So you're angry and irritated. You want to be away from him, and he doesn't listen. He comes in there anyway.
Yep.
Okay. And you just wanted him to leave you alone. You tell him I just want you to leave me alone.
Yeah, I just wanted some space.
And Legend's your son, right?
Our son.
Our son. And he's in the bedroom on the bed with you.
Yep.
And what size bed do you guys have?
We had a queen size bed.
Had a queen size bed?
Correct.
Different one now?
Yes.
And that queen size bed, I don't know if you're like I am, but do you have like a bunch of stuff at some certain time in your bed, like fold laundry or doing things like that?
Folded laundry. I like a lot of pillows. I don't like to feel like I'm sleeping on a jail bed. I'm not in jail.
Okay. And so there in your room, he's on the bed and you're sitting on the bed.
He was standing and I was sitting.
Oh, you mean Mark was standing?
Yeah.
Okay, I meant Legend. And when you talked to me about it, you said that when you and Mark argue, that it makes Legend cry.
It did that night. We don't typically argue a lot, but that night we were both mad. Yeah.
And Legend's crying.
Yeah.
And he's on the bed with you.
Correct.
start with State's Exhibit 3A and ask you, well, 3A and 3B. Ask if you recognize what 3A and 3B are.
3A is the front of the apartment door. 3B is the wreath and the peephole of the apartment door.
And is that the way it looked on January 1st?
Yes.
So these are fair and accurate, that's what you remember it looking like?
Correct.
Okay. And then 3C, what do we see in 3C?
3C, you see the entry to the kitchen. You see the hallway leading into the living room. And down the back part of that hallway is straight into the bathroom.
Okay. Now when I look at this photo, who is this in the photo?
That's myself.
Okay, and what are you wearing?
Black socks, white shorts, and a gray long sleeve shirt.
Had you been wearing that all day?
Most of the day.
Okay, did that outfit change at all between the time that you texted 911 and the police arrived?
No.
Okay. What are you leaning against there?
The wall.
Okay. And what's this little silver thing down here?
The doorknob.
Okay, and doorknob for what?
The door.
The front door?
The
closet,
apartment door.
the apartment door. Are you holding that open?
Yeah.
Okay, so you're holding open your apartment door. Okay. And why were you holding your apartment door open?
The police needed to take a picture of the entryway.
Okay. And then if we're looking at 3D, E, and F, do you recognize what those are photos of?
Yes, that's pictures of our bedroom.
Okay. And 3D, is that going into your bedroom?
Correct.
3E, a little closer in?
Correct.
And then 3F, that's your bed?
Correct.
And you have your pillows that you like, those that
Yep.
are on there. There's some things that are on the bed there. Were those things on there that day?
Yes.
Okay. So these are fair and accurately show kind of what it looked like that day?
Correct.
Okay. And then there's 3G. Where is this taken?
3G is my side of the bed, closer to the window.
Okay. And so why didn't you sit over on that side of the bed?
There's not as much room on this side of the bed as there was to the other side.
And then 3H, I, J, and K. Do you recognize what those are?
Yes.
Okay. And what are those photos of?
So 3H is Mark's side of the bed. 3I is the bottom looking up to the bed. 3J is another angle of his side of the bed, and 3K is another angle of my side of the bed.
Safe to say it's not a huge bed.
No, it wasn't.
With all the pillows and everything on, it kind of makes it a little bit smaller.
Yeah.
Okay. And when you came in, you sat on what you refer to as Mark's side of the bed, right?
Correct.
And he wouldn't leave you alone, and he came into the bedroom, fair to say?
Correct.
When you came into the bedroom, is it safe to say that he was not happy with you?
We were not happy with each other.
Okay. And when you came in and sat down there, you told him, I just want to be left alone. Can you just leave me alone, right?
Correct.
But he didn't. And when he didn't leave you alone, what did he do next?
Tried to keep me from leaving the area until I was calm because I was mad.
Okay. And when you and I spoke, you wrote a statement to the police department, right?
I did.
Okay. And in that statement, you wrote down what happened that day.
Correct.
And when you were talking to the police that day after they arrived, did you know that their dash cam was recording everything that you said?
No, from what I was told, the audio that you guys had was from the car, not from body cameras.
Did you know that the dash cam that the officer has on his uniform, when he presses that and the dash cam goes on, that anywhere he is, that audio is recorded?
Yes, I'm aware of what it is.
Okay, so did you know that when you spoke to Officer Federico that you were being recorded?
No,
Did you know that when you spoke to Officer Pulaski, you were being recorded?
not that I can recall.
Okay, what about when you're speaking to Officer Witt?
Not that I remember. It's been 7 months.
Officer Grove?
I don't remember.
So if they recorded, if that was recorded on their dash cam, and we can hear the voices on the dash cam, then, and you did have conversations with each of them that day, right?
I did.
And when you talked to them, you told them the same thing each time, didn't you?
From what I can remember, yes.
And it's the same thing that you put in your written statement.
From what I can remember, yes.
When you got that call from dispatch after you texted 911, were you surprised that they called you?
Yeah, a little bit.
You didn't think that the call actually went through, right?
No.
Okay, so when they called back and they asked you if you were okay, you said no.
Correct.
And but you told the defendant that you said they asked if you needed an officer, and you said no.
Correct.
Because if he knew that you called or texted 911 and had the police come there and it wasn't someone else, he would not be happy with you.
No, you wouldn't.
When the officers arrive after you text 911, it's a pretty short time after you text, right?
Yeah.
You hear a knock on the door.
Hard knocking.
Did you know who it was?
No, they didn't make themselves known.
Did you answer the door right away?
No,
Did they knock again?
they did.
And did you go and look through the peephole and see who it was?
I did not. Mark did, and then I looked. But they were not in the visual of the peephole itself.
Okay, so when you look out there, you really see, you see like the hallway?
Correct.
Okay. So when you're looking at the hallway, do you open the door?
I did, yes.
I'm going to show you what's been marked for identification, States Exhibit 1F. Do you recognize where that is?
Yes.
Okay, where is that?
Outside of the apartment door, looking at the stairwell.
Okay, so that's where your apartment is. And when you look out, what part of that hallway area can you see from that peephole?
I would say a little bit of either side of the door frame itself. Like if someone was standing on that doormat, you can't see them. If they're standing too far over near the stairs, you can't see them. It only goes so far.
Okay, all right. And you did open the door, but you don't open it all the way, do you?
No.
Because Mark's standing behind the door.
Correct.
And he doesn't really want you to talk to the police, right?
I wouldn't say he didn't want me to talk to them. He didn't know what I was going to say to them, or he didn't know that I was going to talk to them.
So you open the door, you don't open it all the way. Mark's standing behind the door, and you kind of signal to the police officers, hey, look, he's right here, with your eyes and kind of nod.
Correct.
And Officer Velosky actually asked you kind of, mouths, is he behind the door, and you said yes.
Correct.
And did you feel comfortable talking to the police with Mark standing behind the door?
No.
And so Officer Federico said, why don't you come out in the hall so the dog doesn't get out, right?
Yeah.
And so you came out in the hallway, and when you came out in the hallway, did you stand right in front of the door and talk?
Next to it, where the doormat was. But at some point in time throughout that, I do remember talking to them up near the building door, up on top of that stairwell.
You were upset, and your eyes were red, you had been crying.
Correct.
And your voice was really scratchy and low at that point in time.
Correct.
When you say you spoke to him kind of in the hallway, I'm going to show you what 1G and 1I. Do you recognize, first of all, what 1G is?
That is the stairwell at the top of where those bicycles were, over here to the right. This is the floor above us.
And do you recognize this green door here?
That's the entrance to the building itself.
Okay, so if you come in that entrance, do you go upstairs or downstairs to your apartment?
Downstairs, and this is where I was talking to them at some point in time as well.
Can you put a check mark in the areas where you were talking to him on that. What about in Exhibit 1F? You put a check mark where you were talking to him there. And do you know whether or not Mark is actually looking through the peephole at you, what you're doing?
No. I'm not in the apartment. I wouldn't know.
Right, and when you were describing to me what happened in the bedroom, do you remember drawing a diagram for me?
I do.
I'm showing opposing counsel what's marked for identification of State's Exhibit 4. May I approach? Do you recognize this drawing?
Yes.
Okay, and how do you recognize that?
I drew it so you could have a better visual of what the bedroom looked like.
Okay, and what happened that day?
Correct.
So if we're looking at this, there's a rectangle with like some scribbling at the top, and then what looks like two rectangles, and they're almost like looking like eyes. What is that?
That is the bed.
And that's supposed to be your bed?
Correct.
Can you label that with this, just right, bed? And then there's a box below that that you drew. What is that?
That is the TV stand.
Okay, so that's the TV stand right there?
Correct.
Okay, can you mark that? And then to the right of the bed, there's like a rectangle with a dot in it. What's that?
The bedroom door.
Okay, can you put on there that's the bedroom door? And looking at the bed, there's like a little stick figure drawing here kind of towards the bottom of the bed. Who's that?
Legend.
Okay, can you put Legend's name there? And then the other diagram, the other sick people that are there are kind of two of them. The one that's laying, if you're normally would lay on the bed this way, you're kind of going the other way, like horizontal on the bed.
Mhm.
Who is that person right there?
Me.
Okay, and who is that on top of you?
Mark.
And you described that Mark was actually on top of you?
Correct.
Okay, and that he had his forearms on your neck and your chest.
On my chest. I was laying on the bed, so my chin was like this.
Okay, and he was laying like this on top of you
Correct.
with his full body weight
Correct.
and pushing down on you,
Yes.
and you couldn't breathe. Fair to say you couldn't breathe?
Yeah.
Okay. And you asked him to stop,
Correct.
and he didn't.
No.
And you said it felt like it was 15 to 20 minutes that he was doing this.
I could have exaggerated.
It felt like it though, right?
Felt like it. I don't actually know. I didn't time it, so I don't know.
But during that, you said that you were choking and you felt like you were seeing blurs. What does it mean by you're seeing blurs?
I started to panic. I was angry, mad, wanted to be left alone. I tend to get very combative when I'm held down.
But you couldn't hear him, could you? Because he had his whole body weight on top of you, right?
No, I was fighting him, tussling with him.
Okay, but you couldn't roll because Legend was right there, right?
Correct.
But you had to fight with him to try and get him off you and to leave you alone. But he didn't, did he?
Correct.
And so you guys start arguing over this unsent message on Facebook, right?
That's what started it, yep.
You asked him to leave you alone, right?
Correct.
You didn't want to agree, and so Mark starts yelling at you, and you went into the bedroom.
Correct.
He wouldn't leave you alone. Right?
Correct.
And he pushed you on the bed. When you and I spoke about how he pushed you on the bed, this was not a light push. He pushed you so you went back on the bed.
Correct.
And he had his arms crossed underneath your chest and your neck. Do you remember writing that?
Writing it, yes. Correct.
And you said you couldn't breathe. And you asked him multiple times to stop and let you go, and then his whole body was on top of me. You remember saying that?
Correct.
He said, you keep comparing me to your ex, and I'm going to abuse you like he did, so you can say I abused you. Do you remember him saying that to you?
Correct.
And that to you was really bad.
It pissed me off.
And he knew what happened with your ex, and so saying that, did that make you afraid?
Not afraid, it pissed me off. Like, really bad.
You said you looked at him and you started to see blurs and you couldn't breathe steady. And he let up, he didn't let up, and so you said no, he told you no, you're gonna listen to me.
Correct.
And you didn't wanna listen to him.
No.
So then you tried to roll, but Legend was there, laying on the bed, screaming and crying.
Correct.
So you tried to stop, you realize your son's there, you don't want anything to happen with him, so you try and calm the situation down.
Correct. I was also getting tired of tussling with him, trying to get him off of me when I asked him to just leave me alone.
So he finally, after what felt like 20 minutes, he finally gets up. But you wrote in your statement, after 20 minutes on fighting him while he choked me.
My definition of choked is just someone laying on top of me or
Where you can't
keeping me from getting up.
Right, and where you can't breathe, right?
Yeah, but that wasn't because of him laying on top of me. That was a mix of me arguing with him, screaming, tussling with him. I was starting to get tired. I just wanted to be left alone.
Trying to get up, right?
Yeah.
He wouldn't let you up, and the way that he had his arms pressed against your chest and neck, didn't you tell Officer Federico that your voice was raspy and hoarse because he was choking you?
I don't recall.
If it's recorded on dash cam, would you agree that that's what you said?
Agree to what I said? Yes. Agree to what I meant? No.
But you said over and over and over again that he had been choking you, right? To multiple officers, you said that he had been choking you and you couldn't breathe and you were seeing blurs and your voice was raspy as a result of it. True?
To the officers, yes.
Okay, and when you did, when you wrote out your intent to go forward with charges and that you wanted to prosecute, you said that he was choking you on the bed, right?
Yes and no. I said that he put his full body weight on top of me, laid on me. The officers asked me multiple times, did he choke you like this around your neck? Did he put you up against the wall? And I said no. They said, can you give us an example? There's a bulletin board in the hallway of the apartment building that I physically and visually showed them how he held me on the bed. He did not choke me. I was pissed off, wanted him out of my house, wanted to be left alone for a little bit. So I told them and I showed them, and they just kept asking me the same thing.
But it wasn't, he didn't put his hands around your neck and choke you like we would normally think, right?
No, but that's my version or my thinking of choking.
Okay. I'm gonna show you, I'll show opposing counsel states exhibit 5.
I would object, that's a charging document.
Not gonna admit it.
Well, listen, there's an objection. I don't want any discussion unless it's up here, so come up here.
first if you recognize what that is.
And it's a document that the police had me sign.
Okay, and so your signature is on here, right?
Correct.
And it says 1/1 of 25, that's your handwriting, right?
Correct.
And you said that the complaint was because he was choking on bed, right? Is that what that says?
That's what I wrote, but
That's what you wrote, okay, so that's your handwriting.
it's my handwriting, yes.
And when you wrote the written statement out, where did you write that?
In the hallway.
Where in the hallway?
On the stairwell or at the top of the stairwell? Can't recall.
How long did it take for you to write that statement?
I don't remember. Wasn't short and it wasn't long.
Your Honor, I'm going to show opposing counsel what it's been marked for identification as State's Exhibit 6. Can I approach? Okay, so I'm going to have you look at State's Exhibit 6. Tell me if you recognize what that is.
The statement I wrote.
You wrote that, right? Your handwriting?
My handwriting.
And you explained to the police what happened that evening, right?
Correct.
And the words that you used, the word you used there was, after 20 minutes on fighting him while he choked me, right? But your definition of choke, and just to be clear, you're not saying that he put his hands around your throat, but you couldn't breathe from the way that he was pressing down all his weight on you. Is that fair to say?
I'd say it's fair to say that he did not choke me. He did not want me to get up, so he put his full body weight, like I said, on top of me to restrain me from getting up. He laid on top of me, which I wrote that in there.
And you put in there that it was on your neck and your throat area, right? Chest and neck. Chest and neck is where he was putting pressure.
Yeah,
So he was putting pressure on your neck.
on my chest.
It says chest and neck, right?
I know what I wrote, but if I'm laying on the bed and my chin is up and he's going like this, his hands are not on my neck.
So you told the police that, and you wrote in your statement that he was putting the pressure on your chest and your neck, right?
That's what I wrote, but I was also pissed off and wanted him out of my house.
And then you actually, when photos were taken, you actually showed the police your neck and your throat area because that's where he had put the pressure and they wanted to see if you had any marks there, right?
They took pictures of my neck to see if I had any scratches or bruises. That's what they asked me. They asked me about my tattoo that looks the same that it did 7 months ago. I purposely had it made like that. I had no scratches, no bruises, no cuts on my hands or my neck.
Okay. But his full weight's on the bed, you're trying to get him off, and it takes long enough that you just get tired of fighting back with him, trying to get up.
Yeah, I was just over it.
And were you able to roll over at all at any point in time to try and get away from him?
I tried, but I didn't want to. I had pillows on one side of me, and I had my 10-month-old, well, now 10-month-old, on the other side of me.
And when he finally let you up, after what felt like 20 minutes, where did you go?
In the bathroom, I believe.
Okay, so you went up in the opposite direction of where the defendant went.
He was still in the house. It's not a big apartment, but I went in the bathroom, left of our room to be able to get some space to myself.
And to text 911.
Correct.
When the police were there talking to you, why were you whispering when you were talking to them?
So he wouldn't hear me, The walls are paper thin.
Okay, so the defendant wouldn't hear you, right?
Correct.
And even later, when you talked to him on the phone, on a recorded line, he said, "You choked me." Remember saying that to him?
No,
You did, you choked me. You wouldn't let me up.
I don't remember. It's been 7 months.
So, do you have any reason to doubt that that would be recorded?
I don't know. I can't remember.
Okay. Would listening to it refresh your memory?
Yeah.
Bob, would you take the jury back to the jury room, please?
Yes, sir. Jurors meet. All right, the jury.
Okay, go ahead. Hey, who's making all?
Say you gonna treat me like Tone did though. Like that's what made, that's what.
Hold on, start. What's going on out there?
There's a big family out there first.
All right, well, tell Stan to control that or something, will you please?
It still says that at the top of the screen when you open it.
Oh, all right, I'll change it.
All right, go
I
ahead.
think if you go full screen, it should disappear.
Okay.
I hope.
All right, go ahead.
PTSD, you not know what that is?
All part of the same call.
Was it choking me or holding me?
That's your voice, right?
Correct.
Okay, so you just say choking. Right.
Correct.
Does that refresh your recollection as to whether you said he choked you?
Yes.
Okay, bring the jury back in.
And for the record, that stays Exhibit 8. I'm not gonna pull it up on the screen.
You can't play it when they're here.
No, not going to.
All right, jurors, want to come back in, please?
All right, go ahead, Ms. Linden.
Thank you, Your Honor. Face, do you now recall speaking to the defendant and telling him you choked me?
Correct.
And you told him that you had PTSD and that you said he was gonna treat you like Tone and that was a trigger for you.
Correct.
Now, after this happened, you had an opportunity to speak to each of these officers involved, right? You spoke to Officer Witt,
I talked to them all at some point, yes.
and you told them all the same thing that night. Fair to say?
Fair to say.
And when, later on, when you were asked about that, and you were questioned by Job and Family
Correct.
And each time they talked to you, the defendant was present either while you were on the phone or in the same apartment with you when you made any statements to them.
Most of the time, yes.
And fair to say that you might not have been quite as forthcoming with them because of what actually happened.
Correct.
And you didn't want the defendant to know what you had actually said.
Correct.
And for the record, I'm going to showing opposing counsel again to A, B, and C. If I can approach.
Yep.
To A, B, and C. Okay. Can you tell me if you recognize those photos?
2A is myself, 2B and 2C are my shirt and pictures of my neck.
And those photos were taken because you said that part of this happened to your chest and neck, right?
Correct.
And you were pretty upset and you were crying that day.
Correct.
On with the officers talking about it.
I was crying the whole day, even when they left.
Okay.
I was pissed off.
And do you then recall saying to each of these officers that your voice wasn't normally like that?
No, we had been arguing and yelling, so naturally that's what happens.
But you said that, and you told Officer Federico the reason that your voice was like that was because he was choking you and holding you down. You remember saying that?
Maybe so.
And you told him that you were choking and you couldn't breathe and to leave you alone. But he didn't.
Correct.
And repeated to each of the officers that he said that he was going to treat you like your ex and that this whole argument was over a Facebook post.
A message that he received, yes.
And this states Exhibit 6, these are your words, right? Your words about what happened.
Right at a time that I was pissed off and didn't want him in my house, sure.
Okay, so let's talk about that. So since you met with me and talked to me a few times, and then after that you didn't want to talk to me anymore. Is that fair?
Fair, yeah.
So when you didn't want to talk to me anymore, part of that has to do with the fact that you work full-time, right?
I work anywhere from 40 to 60 hours a week. My days alternate. I work every Saturday and Sunday. I work sometimes 12 hours a day, sometimes 10, sometimes 8.
And so, fair to say that you're a caretaker for your child.
I need Mark to be my caretaker for our son, yes.
And so, for you, if he is charged with domestic violence or strangulation, that could jeopardize that for you, right?
If he's away at all, yes. It doesn't just jeopardize me, it jeopardizes our son, our family as a whole.
So, when you didn't want to talk anymore about what had happened, and I asked you initially, like, are you saying that this didn't happen? You said, no, it happened, you just didn't want to go forward. Is that fair?
That's not fair. I told you when I met with you that he did not choke me. I did not understand where that charge came from. You explained to me that through the legal system that there are certain stipulations that define that word. Strangulation.
So
Right.
Your definition,
My definition's warped.
Your definition is based maybe more on what happened with Tone.
Yeah, I compare a lot of things to that man.
And so when you look at like the legal definition, and we went through what the charges were and everything, you had a harder time understanding because, again, we're not talking about hands around the neck and squeezing, right? But we have the fact that you said repeatedly in writing twice and then to the officers that he choked you. Fair statement?
Fair statement, yes, but my definition of choking is different from strangulation. I was pissed off. I didn't want him in my house anymore. I wanted to calm down and be left alone. I was postpartum. I'm pregnant now. I just wanted to be left alone so I could calm down. And I told you that when I met with you. The reason why I did not want to talk to you anymore, including this past Friday, is because I had people showing up to my house, the police included. And there was nothing wrong.
You had a meeting on Friday scheduled with me, but you canceled that meeting, right?
Cancel that meeting because I had to go to work. I had appointments. I needed to relax before coming here and sitting here all day and dealing with this.
Well, fair to say that.
And I had people show up at my house.
Well, fair to say that you knew the trial was coming up, right?
Fair.
And based on what happened on January 1st, you can certainly understand that someone might be concerned for your welfare. Fair to say?
Concerned with my welfare, but I emailed you, right? So I told you I was fine. I reassured every party involved that I was coming here, that I'd be here. I had a babysitter set up. I'm here. I'm good on my word. I told you I was coming. I came.
Okay, and you're good on your word, you just said, so.
I'm good on my word in that email that I sent you. That statement, I was pissed off, tired, exhausted.
This statement, the statement to Officer
That statement.
Rodrigo, the statement to Officer Witt, the statement to Officer Grove, the statement to all the officers here separately. You told them exactly the same thing, but now you're saying you're just mad.
In that statement when I wrote it, yes, because they told me they couldn't make him leave my house. He's lived there too long. He gets mail there. They can have him leave, but it doesn't mean he's gonna stay. He could come back.
But they didn't write this statement for you, did they?
No, but
They didn't write these words, did they?
when they asked me about that stuff,
They didn't tell you.
they had me alter it. You see those inserts in there?
Oh, where you added his whole body was on top of me?
Right, because they didn't understand.
So you explained it.
Explained it, and they told me, we'll insert that there,
And you
add
said
that there. That's what I did.
talked and acted
Hold on. You guys can't talk at the same time. One at a time.
Thank you. Go ahead. Do you need another minute?
I need a break. That's what I need.
The only other thing that I see that's kind of written in there is by walking away. Is that what you mean when you added something there?
Every time they asked me a question about what happened when I wrote this statement, if they didn't understand what I was trying to say or how I was describing it, they told me to insert that there, write that there. Can you show us? Can you show us? They asked me over and over and over again, did he choke you? Did he do this? Did he do this? I showed them. So every little writing in here was an insert based off of what I told them inside of the hallway.
Because you wanted them to understand what happened.
And I was pissed off. I was crying. I was upset, like I am now, getting mad. I don't like being questioned, so I started hyperventilating. And I just wanted to be left alone.
And so when you wrote the statement, though, you did your best to explain exactly what happened.
Yeah.
Let me go a moment, Your Honor.
Yes, he's in the courtroom.
Can you please point him out and describe what he's wearing?
He's on the left side of the room in a cream-colored hoodie.
Is the record reflect the identification?
Yes.
Nothing further at this time, Your Honor.
Ms. Smith?
Good afternoon, Faith. How are you?
Peachy.
As you know, I'm Rachel Smith, and I represent Mark. You know that because we've spoken before, correct?
Couple of times, yeah.
Yes, 2 different times on the phone,
Correct?
and that was in preparation for today's trial, is that correct?
Correct.
You and Mark began dating in June of 2023, right?
Correct.
And as the state drew out, you have a child in common named Legend.
Correct.
When was Legend born?
September 3rd of 24.
So around the January 1st of 2025, you still consider yourself in your postpartum period.
Very much so.
Tell me a little bit, or share with the jury a little bit about what postpartum was like for you.
Horrible. Not what I expected. Thought I was gonna be good, happy. Didn't realize I was gonna be dealing with a colicky baby that had a sensitive stomach, mood swings, uncontrollable, unstable emotions that were like roller coasters, sleep deprivation, lack of romantic feelings. I didn't want to be touched. I didn't want to be held. Depression, getting up and enjoying simple things I didn't find enjoyable.
And these are feelings that you were struggling with on January 1st.
Correct.
Had you returned to work at that time, or were you working at that time?
No.
The state's taken you through your statement, your written statement. I apologize for the repetition, but I would like to take you through that as well. I'd like to go basically line by line and have you fill in the blanks, okay?
Okay.
First line of your written statements, you say, "We started arguing over an unsent message on Facebook." You've testified a couple of times that it was an unsent message, and also that it was a message Mark received from another woman. Do you recall today whether it was an unsent message from Mark or a message received?
It was one of those, either a message that he got or a message that he sent. I don't remember. I don't remember him showing it to me. That's part of the argument that came abroad from his messenger. I don't remember him showing me, so I don't remember.
Was this a recent message?
I don't remember. I would say it was an older one that I found and that I wanted answers about.
So it's fair to say that on January 1st of 2025, just shortly after the ball dropped, ringing in the new year, you found a message to or from another female on Mark's phone.
Correct.
And that made you mad.
Yep.
Right. Next line of your statements that you say, "I asked him to leave me alone," and then that you didn't want to argue with Mark Jackson.
Correct.
Were you arguing with Mark Jackson at this time?
Yeah.
Okay. So you didn't want to argue, but you both were arguing.
Yeah.
Okay. And he started yelling at you. Was he yelling back at you?
Yeah, so like I said earlier, he took the phone from me. I became irritable. Yeah.
So he was yelling at you to give his phone back.
Correct.
Then he snatched his phone back.
Correct.
What did you do then?
Hit him in the left portion of his shoulder.
After that, did Mark get physical with you? Did Mark strike you?
No.
Attempt to restrain you at that point?
No.
Did he hit you back?
No.
But you continued to argue.
Continue to yell at him, yeah.
And you told him to leave,
I told him to leave the apartment.
but you and Mark lived together, correct?
Correct, but he's not on my lease.
He's not on your lease, so is there any other place that Mark sleeps?
No,
Is there any other place that Mark receives mail on a consistent basis?
no.
So if Mark were to leave your home, would he have another home to go to?
Objection.
Overruled.
No.
So Mark was not required to leave his home too in the middle of the night because you were mad and ass.
Correct.
So you went into the bedroom, which is your shared bedroom, correct?
Correct.
And he continued to bother you, correct?
Correct.
And now we get to the point where you say that he had his arms crossed up underneath my chest and neck. Now the state has placed great emphasis on he had his arms on your chest and neck.
Yeah.
Please explain for us and especially for the jury, what you meant when you said his arms were crossed up underneath your chest and neck.
I was laying on the bed like this, okay? Say this is my head. His body weight was like this. I'm not trying to say this to be funny, but I'm postpartum, my neck's a little fat when I lay down. So when he put his arms like this, it went like this, straight down onto my chest. His knuckles, parts of his hands, were on my chin and my neck. That's why I said my neck and my chest.
At any point when he applied pressure underneath your chest and neck, did he apply pressure to your neck?
No.
Did you ever feel pressure on your neck?
No.
At any point did he apply pressure by any means to your throat?
No.
At any point did he cover your nose or your mouth?
No.
Based on your own experience of these events that you're describing, did you feel as though your airway was closed up?
No.
Did you feel like your blood wasn't circulating?
No.
You indicate in your statement that his whole body weight was on top of you. How tall is Mark?
About an inch shorter than me. 5'7", 5'8".
And about how much does Mark weigh?
Probably about 220, 230.
I'm not going to pry, but does Mark outweigh you?
No.
And you've indicated that you couldn't move while he was on top of you. While he was on top of you, were you able to squirm at all?
Yeah.
Were you fighting back?
Yeah.
Were you yelling?
Yeah.
What else might you have been doing?
Sweating, trying to wiggle. I spit on him, trying to get him to get off me. I was crying, and I started to panic because I was being held down.
And as a result, you couldn't breathe.
Right, I was tired.
Let's explore why you couldn't breathe. You've shared some of the effects that your prior trauma still has on you today. Can you share with the jury any additional experiences that you believe impacted how you experienced the events of January 1st?
So throughout my young adulthood, I've been combative with police. That's a known thing based on my criminal record. I don't like being controlled. I don't like being told what to do. I don't like feeling restrained or kept in a certain area for too long of a time. I like my freedom. If I want to get up, I want to get up. But mentally, when I am being kept from doing what I want to do, or in a small space, due to my past trauma, I start to panic. I start to breathe heavy, fast, rapid. It's like a fight or flight for me, whether I'm in danger or not.
So, based on what you described, do you feel these things even when the danger isn't real?
Yes.
And some of the triggers for these symptoms arising, or your symptoms being exacerbated, when you're physically threatened,
Yeah.
when you feel that your stability is threatened,
Correct.
when your family unit is threatened,
Correct.
when your housing situation is threatened.
Correct.
Now, does your boyfriend at the time, or fiance at the time, who's also the father of your child, does him receiving a text message from another woman threaten the stability of your family unit?
No.
No?
Does it affects our relationship unit, but not our family unit, no.
Can you explain a little bit what you mean by that?
So family unit meaning me, our child, and Mark. Whereas when I say our relationship unit, just me and Mark. That doesn't threaten my kid. It doesn't threaten us as a whole. It threatens the trust that I have with him.
So it threatens your romantic relationship, but not your family unit.
Correct.
Okay. Now, you indicate that you asked him multiple times to stop and let you go. Were you asking politely?
No.
Were you giving him any behavioral reason that it would be a good time to let you up?
Other than me being tired and breathing heavy, no.
And at what point did you compare Mark to Tone?
When he put his body weight on top of me.
Okay. And who brought Tone up first that night?
Me.
And so after you compared Mark to Tone, Mark made a comment about Tone.
Correct.
And then he said, no, you keep comparing me to your ex, and then I'm going to abuse you like he did so that you can say I abused you. This is something that he said, right?
Correct.
Did he then do what he said?
No.
What effect does it have on Mark when you compare him to Tone?
Well, I think it's fair enough we can all say that Tone wasn't a good person, which is probably degrading to Mark, probably hurtful, because he's not Tone at all.
And because you know how hurtful the comparison can be, that is something that you raise when you're angry.
Most definitely.
Now, what Mark said in reference to Tone was a crummy thing to say. Did hearing it make you even angrier?
Yeah.
But he did not follow through on those crummy statements.
Correct.
He did continue to restrain you.
Correct.
You said that you looked at him and started to see blurs and couldn't breathe steady. We've already talked a little bit about the difficulty breathing. Why were you seeing blurs?
I think it's a mix between my PTSD, me getting tired of yelling and screaming and tussling with him. But it wasn't because I could not breathe.
Were your eyes filled with tears at the time?
Yeah.
And then he didn't let up. He said, you're going to listen to me. What was he telling you?
Pretty much to calm down, or he wasn't letting me go.
And then you talk a little bit about how you didn't want to roll over on Legend. And you said you talked and acted calmly, so he let me up by walking away after 20 minutes of fighting him while he choked me. So he let you up as soon as you calmed down.
Shortly after, yeah.
Now, the struggle between you and Mark, you've described as lasting between approximately 15 and 20 minutes. As you sit here today, do you believe that the struggle between you and Mark lasted that length of time?
No, it felt like it. I probably exaggerated. It's not like I had a watch on or a timer. It was an estimate when I wrote that.
And during the time where you were restrained on the bed, did you lose the ability to speak?
No,
Did you become unable to scream?
no,
Did you lose consciousness?
no,
Did you lose bladder control?
no,
Did you lose bowel control?
no,
Have you lost any memory of the events that occurred in those 20 minutes?
no,
Afterwards, did you have a single mark, scrape, or bruise on your neck?
no, I did not.
Were you in any pain?
No,
Were you injured in any way, shape, or form?
no.
Did EMS assess you at the scene?
Nope, I refused their services.
Did you at any time, even in the days after, feel that you should see a doctor as a result of what occurred this day?
No,
In the days that followed, did any bruising or marks of any kind develop?
no,
Did you observe any broken blood vessels in your eyes,
no,
across your cheek?
no.
You texted 911, but it said it wasn't connected. And the last line of your statement is that as of January 1st, 2025, you do want to pursue charges. Were you still mad when you wrote that statement?
Extremely mad.
You were mad about the Facebook message,
Mad about all of it.
mad about his crummy comment in reference to tone,
Correct.
mad that he restrained you,
Correct.
mad that he wouldn't just leave. when you said
Correct.
leave. And you pressed charges because you wanted him out of the house for the night.
Yep.
The next morning, how did you feel? Were you still angry the next morning?
No, I wouldn't say angry. I was sad.
If you had rewritten your written statement at 6:15 that morning, would it have been the same?
No.
Sustained. Jury's instructed to disregard that answer in question.
You previously shared a little bit about your own personality. So when you're angry, do you calm down quickly?
No, not at all.
How long can you hold a grudge?
A long time.
Sustained.
How soon did you realize that you no longer wanted to press charges after the police left?
Maybe 3 or 4 hours.
When did you ever let police know that you no longer wanted to press charges?
I did.
When did you first alert police to this?
It was the next day. Maybe the same day because I'm pretty sure it was midnight when they came, so it would be the same morning, actually. I called them. I didn't go up there. I called them and said that I wanted
Come on
to
up here.
withdraw.
Hold on.
So suffice to say that your official version of what occurred on January 1st is different today than it was on January 1st.
Correct.
You've indicated that's because you calmed down. Are there any additional reasons that factored in to the changes in your statement?
Yeah. There are. I was feeling guilt. I did hit him in the shoulder, so I initiated it. I did yell at him. I did spit on him. So I was feeling guilty for what I did as well.
The assistant prosecutor talked to you a little bit about the volume of your voice. And you agreed that the volume of your voice was low so that Mark wouldn't hear you. Why didn't you want Mark to hear you?
I didn't want him knowing that I didn't want him to stay there, that I wanted him to leave, that I was going to ask them to make him leave, but they couldn't.
Did you not want Mark to hear everything that you said because not all of it was accurate?
I could agree.
You are the only person in your household working right now, correct?
Correct.
And Mark is a stay-at-home dad, correct?
Correct.
And if Mark weren't part of your household, you might have difficulty.
Objection.
Sustained.
Can we sidebar? No further questions.
Ms. Linden?
Thank you, Your Honor. Faith, when we talked about your statement, when you and I met, and I asked you, you're not saying that these things didn't happen, you said, no, I'm not saying that, I'm just, you were just upset that that we're here. Fair to say?
Yeah.
So when you said that you couldn't breathe, and you described how his arms were crossed up underneath your chest and neck, and you said that his fists were on your neck, right?
I said his fists, his knuckles touched the bottom of my chin.
So that's right along the lines of underneath your neck and chest with his fists, and you couldn't breathe. And you asked him multiple times to stop and let you go, and he said no.
Correct. that wasn't due to him choking me or strangling me.
But you put in your statement, then, when this happened, back then, on January 1st, you told all the police officers that it was because he choked you and you couldn't breathe. And you started seeing blurs as a result of that, and that your voice was scratchy, and that you had that voice like that because of what he did to you.
It was a mix of me yelling, screaming, us arguing.
You didn't put any of that in here. What you put in here was exactly what happened that day, didn't you?
I put in there what I had to so they would get him out of my house. I didn't want him in my house anymore.
So what you said over and over and over and over to the police about what happened, would it surprise you if there's no indication anywhere that you put your hands on him?
Would it surprise me?
No, I mean, we talked about this, and you said that when you were arguing and you pushed him away on his shoulder, that was about 20 minutes prior to this, right?
Maybe, I don't remember.
Safe to say that the defendant is pretty strong?
Can be. I can be too when I'm not pregnant or postpartum. I'm not a small girl.
And so when you compared him to Tone because he was holding you down like that made him mad, didn't it?
Yeah, I said that.
And you were upset about what was happening to you because certainly you didn't want something to happen to you like what happened with Tone.
I didn't want it to turn into anything like that, no. That's why I wanted to be left alone.
So when he's saying to you that he's going to abuse you like Tone did, that wasn't hurtful.
It was hurtful.
And that was a motivation for him to do what he was doing to you, wasn't it?
I also said that to him to piss him off.
And it worked, didn't it?
Yeah.
And he was pissed off, and he choked you.
Then choke me.
Strained you.
I used the word choke. That's not what happened.
So then the word choked was right. Today you're saying that's not really necessarily what you meant.
My definition of choked
All right,
is
there's no question. Go ahead, Ms. Smith.
No additional questions.
All right, you may step down. All right, we're gonna take a 10-minute break. Don't discuss the case among yourselves or with anybody else. Don't try to obtain any information from another source. a seat. Temperature's gone up 5 degrees in the last hour. I'm not keeping him here till it gets to be 83 degrees in another hour, so that's why I'm letting him go. All right?
I felt good to me.
Huh?
It's always freezing, I felt kind of comfortable, but everybody else is sweating, I know. Thank you, Your Honor. 60? I guess when you sleep.
I got it right in the middle. I'm like, oh my God.
Your AC in that too?
Drop my sweater, but I don't have a minute. I was gonna, but then I'm like, I think I might
mom.
part of it.
I heard you should work until.
I am pretty baby. I'm no longer 72-year-old.
Why are you still standing at attention? You keep making me feel like